Please. My lord, I beg to mention item, my lord, 3 from 12. It's a series matter. In fact, my lord, these matters are parted before Honorable Justice, my lord, A.D. Chaudhary. There are orders, my lord, passed. But due to, my lord, item number 3 was tagged, my lord, afterwards. And perhaps in that matter, my lord, the order is not reflected. So therefore, my lord,
Notice has not been issued, my lord.
Perhaps.
Audit reason matter is coming up.
Okay, 3 to
12, my lord.
3 to
12. In connection with item numbers 4 to, sorry,
3.
in connection with, this is numbers, huh? 4 to
3 to 12, my lord.
No, it will be 4 to 12.
My lord, correct.
It has, it has been jointly submitted by the learned senior counsel of the counsel for both sides that the matter was substantially heard before another bench, within bracket, Honorable Mr. Justice A.D. Chaudhary.
Right.
Bracket closed. However, as WPC 1714 of 2024 has been subsequently filed, this these matters have been tagged to the motion column. Next paragraph. In view of the said submissions, the registrar shall examine and list the matter before the appropriate bench. Within bracket, A.D. Chaudhary, Honorable Mr. Justice A.D. Chaudhary.
Along with my matter, it would come up. Along with item number 3.
Oblige.
May I please, your lordship, with the consent of other side, lordship, I beg to mention item number 54. Due to some personal difficulties today, lordship, from after 2, I've taken the consent of other side. Lordship.
Consent of the side, Mr. Justice White, and counsel for respondent number 2, place for adjournment, where is allowed. List after
2 weeks, lordship.
2 weeks.
Oblige, your lordship.
May I please, your lordship, my lord, this matter must be listed next week, my lord, because urgency
to the
is there.
court master.
Urgency is there.
All prayer for listing, give it to the court master.
May I please, your lordship? My lord, I beg to mention item number 62, my lord. My lord, in this matter, the Mr. A. Chakraborty, an advocate from Calcutta, is appearing for the respondents, my lord. He is not keeping well for last few days, so he could not come today, my lord. And my lord, the matter pertains to, my lord, recovery of excess trail, and a petitioner is going to retire in June, my lord. So may I pray that the matter may be fixed on a fixed date on 20, 24 or 26, my lord. 20, 24 or 26, any date convenient to your lordship. The petitioner, advocate for petitioner is also here, my lord.
Make it 24th.
Yes, madam.
Notes. Oh, no, this must be done. 26th then.
Yes, madam.
What is represented on the prayer made by Mr. D.P. Bharat and counsel for the respondent. The matter stands adjourned today. Next paragraph. The learned counsel for the petitioner submits that there is some urgency in the matter as the petitioner would retire in this month.
Yes.
Next paragraph. Based on 26/6/2024.
Oblige, madam.
Oblige.
May it please, my lord. My lord, item numbers 13 and 14, my lord. These matters were supposed to be listed in the admission column, my lord. Notices were issued on 2/4/2024, my lord. And in item number 14, state has already filed their affidavit also, my lord. 13 and 14.
It's okay, let it reach.
Lordship.
May it please your lordship. Lordship, with regard to item number 55, I am praying for adjournment for the day. I have taken the consent of the petitioner advocate, my lord.
50?
55.
55, okay. Consent on the other side, the learned counsel for the respondent place for adjournment, prayer is allowed. List after a week.
Oblige your lordship.
May I please, your lordship? Lordship, with consent of the other side, I beg to mention item number 63, lordship. 1 week time may be given, lordship. Take for 1 week, lordship. For adjournment, 1 week adjournment, lordship. I'm paying for 1.
Okay.
With consent of the other side.
Both sides are represented on the prayer made by the learned counsel for the petitioner, list after a week.
May it please your lordship.
Lordship, I beg to mention an item for listing.
Listing, give it to the court master.
Lordship,
May I please,
obliged.
Lordship? I beg to mention item number 31 for kindly the matter may be adjourned for 2 days. And posted for up to 2 weeks. I have taken the consent of the other parties.
Okay. On the claim made by the counsel for the
And Lordship,
petitioner, list
there-
after a week.
There is interim order and an interim order may be.
Interim order passed to this and is extended till the next date of this.
But here, Lordship, even if this pertains to transfer of the petitioner, Lordship, in long back, we have filed the affidavit, Lordship. So even if they are seeking adjournment, Lordship, kindly fix it next week, Lordship. They are taking advantage of the interim order, Lordship.
There are 2 weeks.
This is item number
31.
31, Lord.
31. Okay. That is in adjourned for me. As a stay is operating in favor of the petitioner, list as a fixed item on 12/6/2024.
Lordship.
Maybe Lordship, item number 16, my lord, consent the other side, my lord, after weeks.
Okay,
16.
15, okay.
One six.
List. After a week as paid for by non-counsel for the petitioner. Item 15, you are not there.
16.
1/6, okay,
One.
16. Okay,
Obliged.
Daily list item 1 for motion.
the date of the order,
My lord, at page 11, 6/11/23. my lord.
6/11/20, okay.
Fine.
Mr. Gazmi, contempt. Next steps within 2 days.
13, 14, 15.
Pendency shall not be a bar. Give a returnable date after 5 weeks, after vacation.
The pendency may not be a bar for them to comply. Pendency may not be a bar for.
It's not an order.
Obliged.
Item 2,
So I just did it. Yes,
May please your lordship. Lordship, matter relates to appointment on compensation ground, lordship. Petitioner case was considered by the DLC lordship in the year 2015, lordship, page 27, lordship. And
2014, we are not entertaining after 10 years.
lordship, but lordship, that was lordship for approved by the district level committee, lordship. Thereafter, that was forwarded to the state level commission
And
committee.
now after the Supreme Court judgment, we can't entertain.
So my only submission is that, lordship, considering the circular issued by the government of Assam, lordship, in the year 2015, because they rejected, state level committee rejected on the ground that, lordship, there is no post.
No,
Vacant
Supreme-
post.
Supreme Court has come harshly against these matters. Once there is a delay,
Yes, delay is there, lordship.
judgment of this court and the Supreme Court has now said that even if there is a delay on part of the state,
Yes.
that is also a covered situation.
Otherwise, petitioner is suffering, lordship, because that's why last occasion this honorable court directed the state respondent whether that state level committee minus were supplied to the petitioner or not, that instruction was sought for.
Even those lapses, you see, after the Supreme Court judgment, we don't have any scope to
Yes, I understand, lordship.
scope, otherwise it would be disobedience of the order of the Supreme Court. We have to
Otherwise,
close
since
it.
2014, lordship, he is approaching the department, lordship.
I understand, can't be helped. But Mrs. P. Bhattacharya and counsel for the petitioner. And Mrs. M. Bhattacharya Leonard. Additional senior government advocate appearing for the respondents. Next problem. In brief, the case of the petitioner is that his father, late Deepak Kumar Burman, who was then serving as a grade 4 employee in the capacity of a roller handyman in the establishment of the executive engineer, PWD, within bracket, RR, bracket close division, Dhubri, and died in harness on 13/8/2014. To stop. Without any delay, the petitioner submitted an application for appointment on compassionate ground in any grade for post. Had applied on 7/11/2014. Any post, as there was no earning member in the family. Post stop. The district level committee, in its meeting held on 11/3/2015, recommended the name of the petitioner for appointment on compassionate grounds. Mr. However, the petitioner did not receive any communication as to the fate of his application, despite approaching the authorities on many occasions. Full stop. In the first week of February 2024, the petitioner collected a copy of the minutes of the state level committee meeting held on 31/12/2018 and came to know for the first time that the state level committee had rejected the recommendation made by the district level committee in Dhubri on the ground that the 5% quota had already been filled up. First off. Next, the learned counsel for the petitioner has referred to the office memorandum dated 1/6/2015, and it has been submitted that the rejection of the candidature of the petitioner is vitiated on account of the fact that the directions contained in clause 14. It is 14 or 15?
15.
Clause 15 of the office memorandum dated 1/6/2015 was not considered. First of all, it is also submitted that because of the said error on part of the respondent authorities in the SLC while dealing with the matter, this court, by order dated 23/2/2024, had directed the government advocate, extending counsel for the PWD to obtain instructions as to whether the decision of the SLC was communicated to the petitioner. First, it is submitted that the counsel for the petitioner has submitted that in view of the non-communication of the said SLC decision, that the petitioner has caused the delay for which the petitioner is not responsible. Next one. Could be the additional senior government advocate in the matter. Next one. It is noticed that the Supreme Court of India in the case of State of West Bengal versus Debabrata Tiwari, AR 2023 SC 1467, equivalent to 2023 0 Supreme SC 191, had felt that the inordinate delay, even in part of or even on part of the state to consider the application, would make the petitioner disentitled for consideration of appointment in compassionate ground. First off, the observations made in paragraphs 7.4 and 7.5 of the said cases extracted below. Next paragraph. Same paragraph 7, WBC 2906 of 2024. That's why in light of the actually down in the set in the judgment referred above, comma. What is of the considered opinion that in light of the said decision, comma, the as the father of the petitioner had died on 13/8/2014, the the petitioners is not this is not entitled for a consideration for appointment on compassionate ground. Accordingly, comma, the court is inclined to dismiss this writ petition. That's why. However, comma, taking note of the fact that the petitioner has waited for 10 years, it is provided that in the event the petitioner makes an application for appointment in any other post, he would be entitled to make appear before the competent authorities for for condoning the age bar for applying for any post. By producing a certified copy of the order before the competent authorities. Accordingly, this application is dismissed.
Obliged.
Yes,
Lordship, the last line, Lordship.
has to be because he is waiting for, I mean, Mr. Nayak, I did not see you. Mr. P. Nayak is standing also for PWD.
I'm waiting for 1, 2, 4.
He's now 22. He's not, today he's 22 years. Is it?
Yes.
But since something is wrong then, he can't wait. He could not have applied when he was 12. Something is wrong.
Instead of that, the entitlement ward lordship, if lordship say he will not be barred in participating in any other.
That's what I'm saying. But he can apply for extension of age. He was waiting for 10 years. You see, Mr. Nayak, in the last occasion, we had even imposed a cost of 10 lakh rupees on the 5 lakh rupees on the respondents. I was thinking that if this cost multiply, it would be more harsh on the state rather than allowing persons to apply for condonation of age. That would be more better. Because you see, if you don't comply with your own directions in the OM to communicate at least.
That is their lordship. But for condemnation also lordship, there are OMs are there lordship. In terms of the OM, if he is entitled lordship, then it will be.
Yes, in terms of
In terms of the applicable OMs.
obliged.
Obliged, Lordship.
Item 13 with 14.
In this matter, your lordship, on 2nd of April, my lord, your lordship may kindly 2/4/2024. This item 14, my lord. 13, same. In item 14, they have filed affidavit. 13, they have affidavit yet to be filed, my lord. My lord, the issue is, my lord, In the order, notice part is not reflected. That's why I think it is returnable date is written here also. Page 5 of the order. Pass it, item number 14.
We'll issue a formal notice.
My lord, I think,
You provide your response,
Lordship.
but on merit,
my lord,
your petition may be dismissed also.
my.
Well, I have a question where you don't have an answer. Now, please tell me,
My lord.
you have experience in the trial court, correct?
My lord, little my lord,
And
not
a little is okay. Now, please tell us, in what manner the departmental proceeding record can be introduced in a criminal trial?
my lord, the issue, what I, my lord, disciplinary proceeding and criminal proceeding can go together, my lord. There is no dispute that.
No, it's not only that.
But-
I'm asking you this question in light of the decision of the
Because, my
Supreme
lord,
Court in
state-
various cases
my lord,
where it says that you will suffer prejudice. Correct? So
True.
that is the only point. That's why I'm asking you, in what manner do you propose that, supposing you are the public prosecutor today,
my lord.
please tell us the manner in which you propose to introduce departmental proceeding record in a criminal trial.
Because, my lord, the statement, evidences, whatever, because it is completely based on that.
No, I understand, but please tell
So,
us,
My lord,
how do you introduce?
it
Will you start asking questions to you're a public prosecutor? Will you start the examination in chief of the witness by saying that, well, in the cross examination or in the departmental proceeding, this is the statement you gave. So
but
what
it
do you
can
say?
be, my lord, mold, my lord. When they came to know
You can't.
prior to that, my lord,
You can't.
if in departmental
We give
proceeding.
you time. You have 2 weeks time.
My lord.
You ponder over it and you tell us. No, there is no answer.
How prejudice, how it
This
will go,
point I have raised in this court not less than 10 times,
my lord.
and I have not been able to get an answer. I have checked up the relevant laws relating to the departmental proceedings. Whatever little I can I
The
can
experience-
research.
Which your lordship, so far as lower park court is concerned, my lord. The apex court in the judgment, right?
No, it has said, but
My
you see,
lord.
we'll have to test it on
My lord,
on the
true.
touchstone of the evidence it can be led.
True.
Here, I have my own reservation as to the
True.
manner in which, because unless the public prosecutor cross-examines his witness, he will not be able to bring the departmental proceeding record in a criminal trial, number one. Second is that a record of what you call, in a criminal trial, whether it be under the PC Act or whether it be for any other law, the prosecution depends on the police papers,
Yes.
which form a part of the charge sheet.
Lordship.
And evidence which is recorded in the departmental proceeding will not form a part of the police papers.
Yes.
Correct?
To my lord.
It will not be introduced. There's third reason. When an evidence against the statement under 161 is led, the lawyer must know the art of bringing forth the contradictions. That is the art of the lawyer.
Right.
If I'm just imagining,
Right.
if I am that side.
Right.
And if evidence contrary to the police papers are introduced, it should be a good day for a lawyer. Instead of coming to court saying that there is prejudice, I think it would be appropriate to allow them to introduce such evidence and then cross-examine the witness. This is the third thing.
My lord.
I tried every possible cause. I don't find any reason
True, your lord.
why this court will record that you are suffering a prejudice.
True.
Second, fourth question. Can a departmental proceeding get access to the CJM court record or the special judge court record and then ask questions to the witness when it is not there in the, along with the charge memo, you have to give the statement of witnesses and the people and the documents relied on.
What, this question, my lord, in the statements, whatever the documents relating to criminal trial, your lordship, that those
No,
documents
no,
were
that may
provided.
be there. But the record of criminal trial will not be introduced in a departmental proceeding.
Here, my lord,
It
this
may
is
be,
the
it may be the
whether
same
I should.
FIR, it
my
may
lord,
be the same FIR, it may be the same charge. But a criminal trial record or the record of evidence letting the criminal court
my
would not be a part of the charge
department.
memo in the departmental proceeding. So even under the first circumstances, you don't suffer any prejudice.
But the plea or whatever we are taking in before the departmental proceeding, my lord,
How does it matter then? How does it matter?
that I will.
Yeah, either your lawyer will be asking him that same question
My-
in leading evidence. You are the accused.
Yes.
So unless your lawyer introduces
My-
that, that is not a defense evidence you will give. Will you come and tell before the court in the departmental proceeding, I was held to be guilty in, for charges number so and so. I was guilty of doing this, I was guilty of doing that. Is that the nature of evidence you are leading?
Will come prepared, my lord. I will try to get whatever the questions raised
Because
by
if
your.
that is the, that
My-
is, if that is the evidence you are seeking that you would need,
My, absolutely.
I would just have to salute you. Not only your parent, but only also to the lawyer who advised him to do that.
Right.
I don't see any reason. But we give you time, in this case.
Notice, formal
Although,
notice.
although the matter was taken up by this court earlier. And earlier, but the limit, but Mr. A. Goyal and counsel for the petitioner submits that notice of motion has not been issued. Next, accordingly, you pass separate orders, huh? Accordingly, issue notice of motion returnable on how much, when
Lordship, 2 weeks, Lordship.
returnable in 2 weeks.
After 2 weeks.
Requisite extra copies of the petition be served on the learned. On Mr. J.K. Goswami, learned
Edison C.
government advocate within
Edison C.
2 days. There's a change in your designation. What is your
No,
designation?
additional senior government.
Additional senior government. List after 2 weeks.
Interim order passed.
Okay, interim order passed release stands extended till the next date of listing. Then in second item. Same thing. And because of the petition submitted, notice of motion has not been issued. So it has also been submitted that in the meanwhile, the respondents have also filed their affidavit in opposition in the matter. Next one. Same order then. Issue notice of motion.
Interim order.
Interim order passed with this has extended till the next date of the same. Mr. Goswami,
Lordship.
since there is an interim order, we'll post it after vacation, it will be easier. For the
Lordship,
court to handle because in
Date
two
may be
weeks-
fixed, Lordship.
Okay. Make it after vacation.
Date may be
Make it
fixed.
on 19/7/2020.
Lordship,
1970.
97.
In 2 weeks, it will be the last week of, last week before the vacation, it will be very difficult to handle.
Deeply.
Item 15.
This is regarding non-consideration of my claim from the cadre of junior engineer to the cadre of assistant engineer in the PWD department. What has happened is regarding my validity of my degree from the Institute of Civil Engineers. Now that
You have instructions, Mr. Nayak?
Instruction I have not yet received, but Lordship, I think this matter can also be disposed of in terms of the order passed at page 67, Lord.
that is my limited prayer, man. That is my.
67.
Let the, yes, it starts from page 63.
Huh.
Let the authority take it all, Lord.
Yes. In fact, we have not burdened your lordship. There are number of judgments. In fact, we have conducted so many cases of junior engineers where similar orders were passed and all of them have given the benefit of promotion.
Okay. As Mr. Nayak says so.
That institution is same, Lordship, that is why I'm saying.
No, it's okay. Once you say that.
Only difference is, the order in page 63, which my learned friend has pointed out, there their claim was rejected, so it was set aside and again directed to pass a reason order. So here in the instant case, my claim has not yet been considered, neither rejected nor.
Mr. P. Bharadwaj, and counsel for the petitioner, also heard Mr. P. Nayak, and standing counsel for the PWD. Next, para. The petitioners, the petitioner claims that he was selected an appointed as a junior engineer within bracket civil, bracket was PWD, while notification dated 30/10/2004. Full stop. The petitioner enrolled himself in the end 2010. The petitioner enrolled himself for this is a diploma course.
My lord, it's a diploma.
Diploma course. And that in the institution of civil engineers within bracket India, bracket was Ludhiana, and accordingly he is cleared in inverted commas section A and B of associate membership examination AMICE within bracket capital I bracket closed in civil engineering inverted comma closed. Full stop. It is claimed that the said diploma is equivalent to a degree in degree of bachelor in engineering. Full stop. Accordingly, the petitioner claims to be eligible for being promoted to the next higher post of assistant engineer. Full stop. Next, it is also projected that in the year 2015, similarly situated persons were promoted. First of however, the candidature of the petitioner was not considered for such promotion. First of. Accordingly, on 23/1/2024, the petitioner had submitted a representation before the Commissioner Special Secretary to the Government of Assam from our Public Works Department within bracket respond number 2. For promotion. Full stop. As I said, representation has not been disposed of. The present petition has been filed in Article 226 of the Constitution of India. Next part. The learned standing counsel for the PWD had sought for further time to obtain instructions. Full stop. However, on the query of the court as to whether the on facts the case of the petitioner is similarly situated to the case of Ashim Kumar Nath, ASHIM Kumar Nath and another versus State of Assam and 4 others, WPC 5104 of 2022, which were disposed of by order dated 8/8/2022, it was submitted that the petitioner is similarly situated. Next paragraph. In this said context, the learned counsel for the petitioner has submitted that as per the case of Ashim Kumar Nath and another within bracket Supra, their representation was rejected and thereafter they had approached this court. However, it is submitted that in the present case in hand, the representation of the petitioner has not been disposed of. Accordingly, it is submitted that on actual metrics, this are the difference. This is a distinctive circumstances in the present case. Next paragraph. Having noted that, that by order dated 8/8/2022, this court in the case of Ashim Kumar Nath and another within bracket Supra had issued a direction upon the respondent number 2 to consider the representation of the petitioners therein with regard to the claim of promotion to the cadre of assistant engineer within bracket civil, with further direction to pass a reasoned order within a period of 2 months. Under such circumstances, the court is of the considered opinion that in light of this said order, this retribution can also be disposed of by directing the Commissioner and the Special Secretary to the Government of Assam, Public Works within bracket Roads, bracket Post Department, to consider and dispose of the representation of the petitioner dated 23/1/2024 by passing a reasoned order within a period of 2 months from the date of receipt of a certified copy of this order, along with a copy of the writ petition with all enclosures. Next paragraph. The writ petition is accordingly disposed of.
Replacement.
Item 17.
May please, Your Lordship.
Just a moment. Yes, they are issuing a notice.
Yes, Your Lordship.
But this is SB Chaudhary and counsel for the petitioner. As well as Miss S. J.
DG,
J.
DG.
D. Jane Leonard. Counsel for the counsel appearing on behalf of the standing counsel for which department?
Lordship, Water Resource Department,
Water Resources
1,
Department,
3, 4 and 5.
comma, representing respondent numbers 1, 3, 4, and 5. As well as Mr. M. Bhattacharya Leonard, additional state committee advocate, representing respondent number 2.
2 on deduction.
Next panel. The petitioner projects that he is a muster roll worker in the establishment of the executive engineer of Water Resources Department and has completed 5 years of continuous service as on 24/1/2021.
My lord, 48 numbers of petitioners, my.
48, you write only one name here. In
In
your,
the first title, my lord.
I don't know, I always don't read the same pattern. In your synopsis, you write only one name. So therefore, I'm copying it from there. Petitioners. Then you say they were appointed in as muster roll workers, oblique, work charged, oblique, sectional assistant. And it is claimed that the case of the petitioners is squarely covered by order dated 5/3/2024, passed by this court in WPC 5823 of 2021. Within bracket, annexure
9.
9, bracket closed. Next, accordingly, if you notice a motion returnable in 4 weeks, because the extra copies of the petition will be served on the honored state and departmental counsel in course of the day. Next para. The respondents shall either file their affidavit in opposition by the next date of listing and or provide due instructions to the honored counsel as to whether the petition can be disposed of in terms of the hearing before referred order dated 5/3/2024, passed in WBC 5823 of 2021. Next, let's start with 4 weeks.
Lordship, I think 19 is also similar.
19.
Yes, your lordship, 17 and 19 are similar cases.
Okay.
Advise it.
Item 18.
May I please your lordship. On last occasion, I prayed for some instruction. Why? Actually, I have received instruction and this case will be more important us than him. Because this some, due to some instruction passed by PVG department, we are unable to, because his right is, similar cases are coming up, my lord. I'll tell you before, submission only lordship, it is written to me, my lord, that is a due permission I'm submitting instruction. Fact, before this one going, my lord, fact is this, my lord. Earlier, master workers, those who are working, their service to be deducted 6 years, thereafter for 20 years, if they are serving, he is entitled for pension. But this notification, this was issued in 25th of May 2009, that has been set aside by Honorable High Court in Chanchitara case. Therefore, all master workers who are continually serving, and if without deduction also, we cannot deduct it, meaning thereby 20 years service, they are entitled. What happened? This communication is made to us. Then we have, thereafter from PPG department letter has gone to us. No, this fact, they have written also letter, they are entitled, but we have to take in cabinet decision and other things. In the meantime, his letter I have submitting very when after 3 times reading only I could also understand. They are writing that those who have approached the honorable court thereafter, they will be entitled. Meaning thereby, people have to come here, then they have to get. But it is not so, should not be so. That is why last prayer I have written also, we have written later. No, the Lordship should observe these things. So that it is a
If
Lordship.
file an affidavit, then we'll come, then we'll see what can be done.
Saying, my lord.
On
No, he is
paper-
entitled, my lord. That
No, no, that's different thing.
Huh.
But if you want an observation of the court, you'll have to file an affidavit, then only we'll take a call.
That's all right. No, here by this letter also you can, because everything is fact is clear, my lord.
No, no. It will be, those are consequences which will travel beyond my hand.
If
I
so,
rely
then in this case,
No,
then-
you see, there, Mr. Barwa, there are two things. Number one, if you produce an instructions, you give an authority to the court to rely on it. But if you say it's a personal communication to you, then it is between you and your department. That's number one, because once you produce instructions with an understanding that the court will act on it,
no, here,
then it will be a document which,
because
by
see-
which the respondent
yes,
will be
yes,
bound.
Lordship is very, but this letter, which is annexing here, taking support of this case, this letter is annexed by him also. That is where, there is a, Lordship pleasure, but he is entitled, that I am saying that,
That's
I don't have any
okay.
objection on that.
That's okay.
Page 55, my lord.
No, no, he is entitled, no need of submission, I am submitting, he is entitled. This letter was, which I am taking support of later,
Page
that
55,
is,
my lord.
মই তোমাৰ পৰা এটা কৈ আছো না,
Sorry.
let them clear,
No,
I am
he's
not denying
contesting.
na.
No, he's contesting.
2610,
You see, he's contesting.
no, once I'm not objecting, very beginning I told that you are entitled. Only between me, why, because we are
You know,
facing difficulties.
there's a story coming out yesterday. Yesterday was Thursday. You read Assam Tribune?
No, I don't read.
You don't read Assam Tribune. In Assam Tribune, yesterday there's a children's page. I start reading from that page. Because young at heart. When I read this young children's page, I find it good. There, what had happened, there's a pictorial story, cartoon. Pictorial cartoon is that a small fish is being chased by a large shark. And then the fish shouts that, please don't eat me. The shark says, what made you think that I wanted to eat you? And the fish says, you are challenging me because I am thin, small, so that's why you don't want to eat me. And then he starts quarreling with the shark. And then the shark says, okay, I think I'll have to reconsider my decision.
He doesn't run past the letter only a change. Anyhow, my lord, if so, and why? Because I'm
So,
taking.
Mr. Barvia, that is the advantage of reading children's book. It gives very good ideas to handle the court. So we dispose of the writ
Yes,
petition.
yes, my lord, dispose. He is entitled.
Yes, now, what is your objection?
No objection, my
No.
lord.
Okay. I heard Mr. A.M. Barvia and counsel for the petitioner. Also heard. PhD will be appearing. You are there, Mr. I. Bhattabha, done it. Standing also for the PhD, representing respondent number 1. Mr. R. Pujari, done it, standing also for the finance department, representing respondent number 2.
7.
Huh?
2 and 7.
2 and 7. Pension will be there? 3, okay. Miss.
I'm for 4,
Mr. M. Bhattacharjee, done it, standing also for the. Sorry, additional senior government advocate, appearing for respondent number 3. So PHE will be 5 and 6 also, huh? PHE will be 5 and 6 also. And Mr. C. Barber and it standing counsel for the respondent number 4. Next one. In brief, the case of the petitioner is that on 12/3/1991, he was appointed as a muster roll worker under the establishment of the executive engineer, PHE, Tangla, under BTAD. Oh, if it is BTAD, then
Lordship, it
you
is a
say
transferred subject.
transfer subject, you'll have to implead. We can't allow this petition. You'll have to implead BTC. Without that, we can't pass any orders. Now, you see that yeah, it appears from the statement made in the synopsis of the writ petition that the petitioner is working in the establishment of the executive engineer from a PHE Tangla division, which is within BTAD area. And it is noticed that the BTC authorities are not arrayed as respondents. The learned counsel with the petitioner prays for and is granted leave to implead the concerned BTC authorities as respondents in this writ petition. Next paragraph. The corrections in the cost title shall be done by providing a freshly typed copy of the cost title to the AOJ civil pending section, who on receipt of the same shall make necessary correction in the central registry and thereafter list the matters in the in the motion column. Whenever you do it, come. Yours written.
Item 20.
Please, your lordship. Lordship, may kindly pass it over for the timing. My senior Mr. Mitra will be hearing this matter. But similar matter notice has been issued already, Manoj.
New NPS. You should notice.
Yes,
Your name?
AK Bodo Lordship.
Let me say AK Barbar and AK Bodo and counsel for the petitioner. You're the as well as Mr. B. Chaudhary, Learned Standing Counsel for the APDCL.
All the respondents.
For all the respondents. Next paragraph. In view of the nature of issue raised in the writ petition, issue notice of motion returnable in 4 weeks. Requisite extra copies of the writ petition be served on the departmental counsel within 2 days. Next paragraph. The pendency of the writ petition shall not be a bar for the respondent authorities to
Similar matter.
redress the grievance of the petitioner.
WPC 2914, my lord, similar matters.
Huh?
2914 of 2024. Similar matter can be tagged together with the same.
Okay, list out of service along with WPC.
2914 of 2024.
Okay. You got the number?
Keep it.
Keep the eye. Yes, 21.
Item 21.
Please, your lordship. Lordship.
Decalculation of family pension.
Lordship, matter may be kindly be taken up to some time. My senior Dinath is in like another court.
It's okay, we are issuing notice. Your name?
Asumi. Asumi.
Yes, write it down. Otherwise, we'll make a mistake. But so and so learn counsel with the petitioner. Just your name?
K. Kulita on behalf of KK Pora. Learned CCC for respondent number 1.
Your name?
K Kolita.
K. Kalita, appearing on behalf of Mr. K. K. Parashar.
CCC Lordship.
Learned CEC, appearing for
Respondent number 1.
respondent number 1.
2 and 3, we have to take instruction that we can appear on.
Next para. Agreed that the communication about the communication dated 13 to 2024, determining the monthly pension of rupees 3,194 and rupees 799 to each of the two daughters of the petitioner. Monthly pension of the petitioner. And claiming it to be erroneous. On the present date, petition has been filed under Article 226 of the Constitution of India. Next, issue notice returnable in 4 weeks. So, requisite extra copies of the writ petition be served on the learned CEC for respondent number 1. Next, the petitioner shall take steps within 2 days for service of notice on the respondent numbers 2 to 6 by registered post with AD. Just post up. The notice is made returnable in 4 weeks. Next paragraph. In view of the projection that the assets of the respondent was the respondent number 4 and 5 corporation are under liquidation with an official liquidator within bracket respondent number 6 bracket was being appointed. The issue of maintainability of the liquidation is left open to be decided in the matter. Next paragraph. The pendency of this litigation shall not be a bar for the Regional Provident Fund Commissioner, EPFO within bracket respondent number 2 to re-examine the correctness of the calculations so made. Next paragraph, list after 4 weeks.
Yes.
22.
Yes, please, Lordship. Lordship, this matter pertaining on the grounds of compensation appointment. My
2015 we can't edit and we'll have to dismiss your petition. This person died, your mother died
mother died 2015.
15. After 15, now we are 9 years down the line. It
After
can't be
DLC,
entertained.
DLC recommended my name 28 2019, page 17.
You see, whatever be the conditions, but once the death is 9 years back, we are bound by the Supreme Court judgments, which says that it should not be entertained. 2 moments back, we passed an order dismissing the one of the writ petitions on the same ground. Be prepared, you make your submissions after some time. Be prepared on the point. Correct, we are not discouraging you, you are a young lawyer, we are not discouraging you, but be prepared. You make your submissions on the issue of the delay.
She may look into the judgment 7.5. Then,
But I'll give her an opportunity to address us.
Right.
They need some encouragement.
Deeply obliged.
Oh, after some time. But please tell the counsel for the other side when you'll be arguing, because they may be busy elsewhere. So give them the time when you propose to argue. Okay, at 2 o'clock. Okay.
23.
The petitioner has
Okay.
determined
Okay,
use that you.
Heard Mr. S. Bharat and counsel for the petitioner and Ms.
Ken Kolita on behalf of TR Gogol, Steady Council of House of Board.
Okay, be slow. Your name,
N Kolita,
Ms. N. Karita, appearing on behalf of Mr.
TR Gogol,
D.R. Gogol, standing counsel for the
Housing Board,
Housing-
Assam State Housing.
Assam State Housing, for the respondents. Next one.
For all the respondents.
The non-payment of the retirement dues of the petitioner quantified at rupees 14,70,160. The present writ petition has been filed under Article 226 of the Constitution of India by projecting that the petitioner had superannuated on 30/11/2019. Next, issue notice returnable on fixed date after vacation. List transfer, notice of return list transfer. Requisite extra copies of the writ petition be served on the London Department of Council.
20%.
Next para. Having noticed that the petitioner had superannuated on 30/11/2019, the respondents are jointly and severally directed to ensure that their affidavit in opposition is filed positively on the next date fixed. List on
24/7. Item 24.
There are some mistake in enclosing the annexes. It's not in sequence logic. So I may be allowed to withdraw the petition, the liberty logic.
Mr. A.R. Taibuldar, learned counsel for the petitioner has submitted that there is erroneous placement of the annexures to the writ petition, and accordingly placed to permit him to withdraw the petition and to refile it again.
Yes, with a liberty logic.
That's right. Ms. B. Sharma, learned CEC, and
A Longcomer,
A. Longkumar, learned counsel for respondent
WPTPC. I am for 1 to 5.
for WBC, WBC and BC department, and Ms. A. Talukdar, learned counsel for respondent to government advocate appearing for respondent 2 and 7 are present. So, the prayer of the petitioner is allowed. The matter stands. The petitioner is permitted to withdraw this petition and to approach the court. And to approach the court again.
Oblige that.
25.
Closed.
Alright. So this writ petition is filed against the departmental proceeding, my lord, by which, my lord, I have been awarded a punishment of dismissal from service. Lord, while I was working as a,
Show me this.
yes, sir.
But Mr. Biswas, learned counsel for the petitioner Who's the respondent?
I'm
Oh,
appearing for
yes.
all the respondents.
As well as Mrs. M. Bhattacharjee, learned additional senior government advocate appearing for all the respondents. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the order dated 18/11/2023, by which the disciplinary authority had dismissed him from service as well as the appellate order dated 3/5/2024, by which the punishment awarded to the petitioner was affirmed by dismissing the appeal. Next one, issue notice, returnable in 4 weeks. Requisite extra copies of the writ petition be served on the additional senior government advocate in the course of the day. Next one, list on so and so. Will the proceedings be required or you have given?
Yes, ma'am. Criminal proceeding is going on.
No. You want the
Discipline.
records of the
The
department
Records will be
proceedings?
necessary, yes.
Will be necessary. Next one, the learned additional senior government advocate shall also obtain the records of the disciplinary proceeding against the petitioner.
Supply item 64.
Who's appearing as CGC here? Please look at this. What is the situation? Please tell us about the retention of the quarters after the after transfer.
Okay,
That is the issue.
government quarter.
Government quarters. You see that there is a retainable period.
Okay.
I don't understand it.
Yes. After that, that cannot be, yes, kept.
Oh, you are there?
That I told, that my senior is.
Oh, yes, Lordship.
Yes, what is the law on the point of retainership of the quarters?
Lordship, so far as Lordship, other cases are concerned, Lordship, they were allowed to retain the quarter till the end of their term. That is somewhere June month.
This is what he is claiming here.
Yes. Now, Lordship, as it is, the matters have been spread out. Some cases have been filed in CAT and some in Delhi also. And all these matters have been transferred to the Guwahati High Court now. So they will be taken up together to decide the issue.
We should notice then.
Yes, Lordship, and it can be tagged with Lordship.
I have the order, so.
If I may take your Lordship to page 14, the Supreme Court order. And I'm sorry, Lordship, NHF 14, page 62.
Supreme Court order.
And
See that.
if your Lordship will come to page 63,
Mhm.
3 cases are mentioned. In fact, Lordship,
I have that.
and the matters in the CAT have also been transferred here.
Okay.
Nine.
Those are 2 other cases. Sir.
But Mr. S. Bhattacharjee and counsel for the petitioner, as well as Mr. R.K.D. Chaudhary and DHJ appearing for the respondents. Next paragraph. It appears from the copy of order dated 2/1/2024, passed by the Supreme Court of India in connection with transfer petition within bracket S bracket close within bracket civil bracket close number 1317-1322/2023 and another connected case. The some writ petitions as well as the original applications before the Central Administrative Tribunal have been transferred for adjudication before this court. Next para. The case of the petitioner is that as per the policy applicable for the BSF, any officer who is posted to Northeastern region is eligible to retain his government accommodation at the last place of posting. And it is projected that though several others have been permitted to retain their government accommodation, the petitioner has been ordered to vacate the GPRA quarter on 15/5/2024 by approving retention of such quarter only for 6 months from 16/11/2023 due to 15/5/2024. Next one. You should notice, including notice of the prayer for interim relief returnable on. What is the date in the other cases?
Lordship, the date has not been fixed.
Returnable on
Lordship, can you make it immediately after the vacation?
22/7/2024. Requisite extra copies of the writ petition be served on the honored DSJ in course of the day. Next para. Till the next returnable date, comma, the respondents shall not take any coercive action against the petitioner. In terms of the office memorandum dated 6/10/2022. Next para. List this matter along with WPC 2577 of 2024, WPC 2598 2598/2024, and any other connect cases.
WPC
of
1211 of 2024. That's the first case. WPC 1211 of 2020.
1211 of 2024, and any other case of similar nature.
Lost. Deeply applied.
On 22/7/2024.
So.
And also your lordship, in terms of OM, and also your lordship, notice dated 10/1/2020.
And notice dated 10/1.
10/1/2020.
24
years.
2024.
Deeply applied.
Item 26.
I please your lordship. Lordship, my senior is Lex in another court.
Okay, we are along this. We are along this in meeting.
For the matter for
No,
time being,
your name?
V. Haklari.
Ms. V. Kaklari and counsel for the applicant. And Mr. I. Bottowood, and standing also for the APDCL. Appearing for you'll be appearing for all the respondents? No.
Lordship, 1, 3, 4, 5, 6, 7. Lordship.
1, 3, 4, 1, 3, 4, 5, 6, 7. Next matter. This interlocutory application has been filed under Order 1, Rule 10 within bracket 2 CPC for implementing the AP for implementing APDCL, comma, AEGCL and APGCL as respondents. First one. Considering the nature of grievance raised in the connected application, comma, this application stands allowed. And the opposite parties whose names and particulars are reflected in the cost title at page 5 of this application are allowed to be implemented as respondent numbers 18, 19, and 20. Full stop. Next para. The applicant shall provide a freshly typed out cost title of the connected rate petition to the AOJ, comma, civil rule pending section, comma, who upon receipt of the same shall incorporate the amended cost title in the connected WPC 2487 of 2024 and also cause necessary correction in the central registry and list the matter in the motion column. Not in the motion column. No, this part of the order don't write here. You say till application stands allowed. Then in the rate petition you write. Heard Mr. Counsel for the petitioner and Mr. I. Butterfield, Leonard, standing counsel for the ABDCL. Next para. In view of the order passed today in the connected IA Civil 1682 of 2024, comma, the petitioner, the learned counsel for the petitioner is directed to provide the amended cost title of this writ petition to the AOJ, civil rule section, who upon receipt of the same shall incorporate the amended cost title in the writ petition and also make necessary correction in the central registry. Next para. Subject to the above, comma, issue notice on the newly implemented respondents, respondent numbers 18, 19, and 20 by serving a copy of the writ petition to the concerned standing counsel for the said respondents. Full stop. Next para. In terms of the previous order of the court dated 15/5/2024, list as per directions contained therein.
Item 27 for admission.
Yes.
16 numbers of employees of Assam Plantation Crops Development Corporation. They have applied for VRS and also for refixing their salary and allowances in terms of 6 pay and 7 pay, as they are parent organization, that is Soil Conservation Department, their employees are getting salaries as per ROP 2010 and 17. During that pendency of this repetition, certain developments have taken place, which I have brought on record by filing an additional affidavit. That is on 30/3/2024. As your lordship may find it, start from 122 page.
Yes.
There, the Assam Plantation Crops Development Corporation, their board of directors meeting that was held on 5th day of April 2022. They have taken various resolutions. The relevant portion is page 138. As per agenda number 29. They have resolved the approval of the board B and is hereby accorded to forward the petition for VRS received from 2 more employees to Soil Conservation Government of Assam, apart from the 16.
Page number 139.
138, madam.
138.
Agenda number 29.
Yes.
Agenda number discussion and on petition for VRS. Managing Director apprised the board that 16 employees have applied for VRS and again petitions received from 2 more employees. Therefore, with the approval
You
of
are
the
reading
board,
138. 130 is agenda number 1, agenda number 2, 3, and 4. Page 138. You are referring to agenda number 29.
29.
Will be 148.
The numbering which my petition is not telling perhaps.
Okay.
The board has accorded approval regarding the VRS proposal.
Okay.
And thereafter, my lord, Annexure 15. By this letter, dated 7th of November 2022. Same was forwarded to the Secretary, Soil Conservation Department. And Annexure 16, 22nd of November 2022, the entire list of employees and everything, details of the bills have been to the tune of 8,35,93,612 has been sent to Soil Conservation Department. Now my learned friend has to apprise this court. What is this present status? What happened to our proposal?
No,
Yes.
you see, there are two compartments of this rate petition. Number one, you're asking for the pay as per the ROP.
Yes.
Correct. For that, I don't find anything here. It says that the application of the ROP rules was accepted for the purpose of this organization. This one. Second part is VRS. Yes, VRS, what is the issue?
May I please, Your Lordship? Your Lordship, I am appearing on behalf of Mrs. R.S. Dury, Your Lordship. Now, as what she has instructed to me, Your Lordship, is that, Your Lordship, the Assam Plantation Corporation Department, Your Lordship, is a public sector undertaking. And it is not the administrative control of that under enterprise is only for a department side is for handled by the Soil Conservation Department. Now, in our affidavit in opposition, Your Lordship, as Your Lordship may very well peruse the affidavit in opposition filed on 13/5/2024, whereas that particular Assam Plantation, Your Lordship Corporation, Your Lordship Limited has been merged with the Industries Department, Your Lordship. And furthermore, we have also stated.
Which affidavit filed on?
Your Lordship, we have filed 2 affidavits, Your Lordship.
Which one you are referring?
Any of the affidavits, Your Lordship, filed on 13/5/2024, Your Lordship.
13/5/24, yes.
Your Lordship may very well peruse Annexure 1, Your Lordship, 153 page number.
Yes.
Your Lordship, may I just read the notification, Your Lordship? In the interest of public service, the Governor of Assam is pleased to merge the Public Enterprises Department with the Industries and Commerce Department and henceforth rename the department as Industries, Commerce and Public Enterprises Department. Now, Your Lordship, the Assam Plantation Corporation Development, Crops Development Corporation Limited is a public sector undertaking. And Your Lordship, that has been merged with the Industries Department.
No,
And
that
further,
has not been merged. It is only the controlling department which has been merged.
yes, Your Lordship.
This corporation has not been merged.
Yes, Your Lordship. And furthermore, Your Lordship, what our stand is that, Your Lordship, the revision of pay is a policy decision which has to be taken care of by the central government, Your Lordship. And furthermore, Your Lordship,
Why central government when when it is under the state? Why central government?
Your Lordship may very well peruse page number 151, our stand, Your Lordship, para 4, sub-para 5, Your Lordship. Your Lordship, may I just read, Your Lordship?
Yes.
That the answering deponent states that the revision of the pay scales of the petitioners as per the 6th Pay Commission or the 7th Pay Commission is a policy matter which purely falls within the purview of the central government. It is for the central government which have to accord permission as it involves financial implication, and the state government has to implement the state decision with the concurrence of the Government of India. The answering deponent respectfully states that by notification dated 5/8/2021, the Principal Secretary, Government of Assam, Administrative Reform and Training Department had notified that in the interest of public service, the Governor of Assam is pleased to merge the Public Enterprises Department with the Industries and Commerce Department. Henceforth, the department is renamed as Industries, Commerce and Public Enterprises Department. Your Lordship, the answering deponent herein states that except the administrative decision with respect to Assam Plantation Crops Development Corporation Limited, the rest of the decisions such as revision of pay, etc., are looked by the Industries, Commerce and Public Enterprises Department.
No, but there appears to be a false statement. The state of Assam or the establishments under the state of Assam.
Yes, Your Lordship.
You say that the pay will be revised by the central government. It can't happen. You show the notification by which the central government, you have abrogated that to the central government, or the central government has taken over the finances of the Assam state government.
Yes, Your
It
Lordship.
will be a false statement. We have to call these people for filing a false
Your Lordship,
affidavit.
I pray that the matter be fixed on a short date.
no,
Let
no.
him come before this court.
Your Lordship, I just pray, Your Lordship.
No, at 2 o'clock you tell us. How do they make this statement that the public enterprises of Assam pay will be fixed by the central government? It's a false statement.
Your Lordship, I just pray, Your Lordship, next week on Monday, Your Lordship.
Every time we don't remember. What
Your Lordship may record that
No.
particular.
You ask them, you ask your planning also to give a phone call to them and then tell us at 2 o'clock what has happened.
Yes, Your Lordship. Much obliged, Your Lordship.
Twenty-eight.
Luckily, we have received the original records.
You got it? Please pass it on.
Lordship, the related pages are the orange and pink flags.
There are two Mofida Khadun.
Lordship,
The petitioner is serial number 1, 2, or 3.
one Lordship,
Serial number 1.
and the respondent number 5 is 2.
I think it's 2.
Why not?
No, this can't sustain. You'll have to set it aside. Who's for appearing for respondent number 5? There's nobody for respondent number 5.
In the causeless Lordship, his name is not been
No one has appeared. I've checked it. No one has appeared. But this has to be set aside. We can't accept this. You know, it's something that when we are making an assessment, and you are preparing a comparative statement, there are not one but many what do you call multiple discrepancy.
Lordship.
Number 1, in the first comparative statement, respondent number 5 has signed at the remarks of the selection committee. This one, this one, he is signing here.
Lordship,
She could not have access to this document
Lordship.
for being signed. So enable her to sign it. That's number 1. Second is, The second statement. Good. Now, it doesn't take a scientific FSL scrutiny to find out this. It is your class, huh?
Lordship, I can't.
You've gone through it. There's the eraser.
That's-
Oh, excellent. And in the third sheet again, there was an excellent which has been rubbed
Yes.
and overwritten by word good. If a person like me, when I'm by spectacle, having both trouble with myopic vision and the distant vision, if I can read this, they can also do it. And how can the state government allow a comparative statement to be written by a pencil?
Gotcha.
This calls for an inquiry. And last is these persons will henceforth not touch the ACRs of the petitioner here.
Gotcha.
This all these three persons, that is MSG president, the supervisor, and the CDPO, will be henceforth prohibited to touch the ACRs of the petitioner. And there's only one good thing about this. You did not try to justify, and your smile has saved them from any further displeasure of the court. But we are setting it aside.
Gotcha.
Can't we have? But Mr. B.K. Das, and counsel for the petitioner, was also heard Ms. A. Talukdar and a government advocate appearing for the respondent, numbers 1 to 4.
1 to 4, Lordship.
None appears on call for the respondent number 5. Next para. The petitioner had applied for the post of Anganwadi worker under Bhawanipur ICDS project of Kokrajhar district. Full stop. She appeared before the interview however, the respondent number 5 was selected for appointment as a Anganwadi worker under the ICDS project, the Bhawanipur ICDS project. According to the present petition has been filed under Article 226 of the Constitution of India. Next para. You were an Anganwadi helper earlier.
Earlier Anganwadi helper. It is my lord for upgradation. The interview is for upgradation.
Next, so it may be stated that the petitioner is presently working as an Anganwadi helper, and the selection process was for upgradation of the Anganwadi helper to the next post of Anganwadi worker. Full stop. Next paragraph. The learned government advocate has referred to the affidavit in opposition filed by the respondent numbers 2 to 4, and it's submitted that the respondent number 5 was selected in the upgradation process to the post of Anganwadi worker of 54 number ROWMARI dash numerical 4 Anganwadi Center. So it is also submitted that the respondent number 5 has completed 10 years of continuous service as Anganwadi worker and belongs to the same revenue village. First, it is also submitted that although the respondent of 5 had passed out her SSCC examination in 3rd division, whereas the petitioner had passed HLCC examination only through compartmental examination. Accordingly, she has justified the selection of the respondent of 5 for upgradation to the post of Anganwadi worker. Next paragraph. Pursuant to the order dated 31/7/2023, the learned government advocate has produced the records relating to the selection relating to Anganwadi Center under the establishment of CDPO Bhawanipur ICDS project from Howli. First off, the selection records has been produced in origin has been examined. First off, on a perusal of the said records, it is noticed that there are 4 sheets of comparative statement. First off, first sheet of comparative statement relating to 54 number ROWMARI-4 Anganwadi Center is contains signature of 3 persons, being the Child Development Project Officer, Bhawanipur ICDS project, namely Bina Rani, BINA, RANI, Devi. It is Devi or Das, I don't know. Devi, I think. Devi.
Devi Lordship.
Srimati Lakshmi, LAKSHMI, Bayan, BAYN, within bracket, SUP, and Afluja, AFLUJA, Begum, within bracket, MSG. MSG means, what is the meaning of MSG? Okay, MSG. Next para. And then so continue. The second comparative statement of the same Anganwadi center contains the signature of Bina Rani Devi, CDPO. First off, the remarks of the selection committee is entered in a pencil. Full stop. The first entry relates to the petitioner. Full stop. Although the pencil remark of good is distinct, comma, the pencil writing of excellent has been erased, but the impression of the erasure clearly discloses that the erased remark is in the inverted commas excellent. Full stop. In respect of, just a moment. In the first comparative statement, we just said in respect of the in respect of entry made in row number 2, ROW, row number 2, comma, instead of remarks by the 3-member committee, comma, the signature of the respondent number 5 by pen has been made. By a ballpoint pen has been made. Full stop. It is surprising that the then access was given to the respondent number 5 to the comparative statement just to enable her to put her signature. Full stop. No signatures of the respondent of the petitioner or the other candidate was taken. Not second one. The second comparative statement, so and so erasure and so and so. Full stop. Against row number 2, in respect of the respondent number 5, the remark is good, inverted commas, good, full stop, excellent, inverted comma closed. Full stop. Therefore, the comparative statement with the signature of Bina Rani Devi, CDPO, is held to be tampered document. Next paragraph. And not next paragraph, second. Or you can give it 1, 2, 3, 4. 4 pages is make it subparagraph 1, 2, 3, 4. Next, in respect of the third comparative statement, which bears the signature of Lakshmi Bayan, supervisor, Majgaon, MAJGON, in respect of the petitioner, the original entry by pencil was excellent. Full stop. There is a half-hearted attempt to erase the said remark. And therefore, the original remark of inverted commas excellent is clearly visible. Full stop. After erasure, after incomplete erasure, a pencil remark of good has been entered. Full stop. However, in respect of the respondent number 5, it contains 2 remarks of inverted commas good, full stop, excellent, inverted comma closed. So however, all the entries are made in pencil. Stop. In the fourth statement, which is signed by Afluja Begum, within bracket MSG, bracket close president. Comma, the remarks are made in pencil.
Lordship, MSG,
First of all, however, there is no apparent erasures.
Matri Hohaya good, Lordship.
Huh?
In the vernacular, it is written Matri Hohaya good, MSG,
MSG, Matri Hohaya Group.
good.
Okay. Next para. There's no doubt. Next para. Although the court is not an expert in examining a handwriting, but a visual appearance of the remarks made in the comparative statement sheet number 2, 3, and 4 appear to be very similar. They were giving an impression as if all the remarks were entered by one person. So the same is also evident from the fact that the word, that the term inverted commas EXEELLNT, inverted comma closed, is the spelling used for the word excellent. And the same mistake has appeared in all the three comparative statement numbers 2, 3, and 4. Therefore, comma, the court is inclined to hold that the selection process of Anganwadi worker for 54 number Romari-4 Anganwadi Center is vitiated by apparent tampering of the comparative statement, and it is evident that the tampering has been done to favor the candidature of respondent number 5. Accordingly, the court has no hesitation to set aside and quash the impugned. Where is that impugned letter, Mr. Das?
27, my lord.
Huh?
27, my lord, please, that is translated from Vernacular 20.
Okay. Impugned order under memo number CDPO within bracket BWP bracket close 119/2018-19/02 dated 28/4/2022. Issued by the Child Development Project Officer, comma, Bhawanipur Child Development Project, comma, Howli, comma, by which the offer of appointment public upgradation of from Anganwadi helper to Anganwadi worker was issued in favor of the respondent number 5, namely Srimati Mofida MOFIDA Khatun KJTY, wife of Abdul ABDUL Alif ALIM. Expera resultantly the district social welfare officer, Barbeta, no, we get the number, no, the director of social welfare assigned within bracket respond number 2 and the district social welfare officer within bracket respond number 3 shall issue requisite directions, issue such requisite directions, as may be required, so as to enable a fresh exercise or evaluation of the Anganwadi helpers for upgradation to the post of Anganwadi worker shall be carried out in respect of number 54 Romari -4 Anganwadi Center. However, having noticed that the that the herein before named 3 persons, namely Bina Rani Devi, CDPO, Bhawanipur ICDS project, Lakshmi Band, with bracket supervisor, and Afluja Begum, with bracket MSG, are all involved in the tampering of the record of comparative statement. The respondent numbers 2 and 3 shall ensure that none of these 3 persons shall henceforth handle the selection process. Moreover, the said 3 persons shall also not be allowed to henceforth handle the ACR of the appraisal of the petitioner in future. Next para. The petitioners shall be allowed to the extent as indicated above. Next para, the original records as produced by the learned government advocate is returned. Next para, the petitioner shall produce a certified copy of the order before the respondent number 3 to bring the order to the notice of, so as to bring the order to the notice of respondent numbers 2 and 3. Next, the entire exercise shall be carried out within a period of 6 weeks from the date of receipt of a certified copy of the order. Next, under the circumstances, we leave the parties to bear their own cost. They can come back.
Obliged.
Yeah, obliged, Lordship.
My lord, I have to go for the
You are removed from service.
Lots.
2019 matter, you will have to bring it on time.
Immediate after the vaccine.
Okay, who is the authority to send you this document, records?
Lordship, Principal Secretary.
Principal Secretary. Okay. But Mr. UG Saikel and counsel for the petitioner. Next, Mr. J. Hendrik Leonard, standing counsel for the Revenue Department, seeks some more time to obtain the records of the departmental proceedings against the petitioner has died.
Petitioner died, man, the who I substitute.
Wife has been substituted.
Substitute.
No, substitution was not allowed. That's the problem.
Substitution was allowed.
No, you did not comply with the order. Have you filed the amended cost title? You did not file amended cost title.
No, that is not final.
At least I don't notice it. Even if you have filed, I don't notice it.
No, I have not filed. For amendment of the cost title, I have not filed, but the party has been
You see,
substituted.
you are taking a risk. This amendment was allowed
Allowed.
by order of 1828 to 2024. Principles of CPC applies. It will have a fatal defect if amendment is not carried out. Because the amendment goes then and your petition will be dismissed. Don't do it. You file an amendment because that's why.
It has not been corrected.
But cross-checking, I found that it's not there.
And nice.
It was relating to what do you say? Difficult records of department proceeding against the you give the name against Gajendra Pathak. Gajendra Pathak. Next para. It is noticed that by an order dated 28/2/2024, passed in IA Civil 2241 of 2023, comma, the amendment of cost title was permitted on substitution of the original petitioner on his death. Stop. Despite directions issued therein, the learned counsel for the petitioner has not filed the amended cost title before the registry within the time allowed. Stop. Now, Mr. Zeki, you are still in trouble. There's a judicial order of 2 weeks. You'll have to file an application to extend the period of limitation. You have to file again. So there's a judicial order. After 2 weeks to accept it, would require a contouring of the period. That's why I said you will be multiplying your work.
Yeah.
You'll have to do it. I can't extend that time. It's a judicial order of another bench. I can't, any orders passed would amount to an review of the earlier order, which I normally should not do. But if you file an application, you can extend it.
I'll file it.
We'll do in the manner permissible. Next para. we take notice of the fact that the original petitioner was removed from service by an order dated 24/9/2014. And thereafter, pursuant to the order of this court, the petitioner was again removed from service by notification dated 2/3/2019. Full stop. Therefore, comma, the who will send you the file? Commissioner and Secretary.
Principal Secretary.
The Principal Secretary to the Government of Assam, Revenue and Disaster Management Department shall ensure that the relevant records of department inquiry against the petitioner is produced before this court positively on the next date of listing. Again, there's another trouble. Now you'll have to amend the cost title. There is no longer a Commissioner and Secretary. So you'll have to again amend your cost title.
Principal Secretary.
Huh?
Commissioner Secretary. Secretary. Chief.
That's for this one. 22/7/2024. 22/7/2024. Now, next one. Accordingly, for that you write, the learned standing counsel for the Revenue and Disaster Management Department shall send a downloaded copy of this order to the concerned authorities so as to ensure the production of the record of departmental proceeding.
All right.
Item 30.
Petitioners before Lordship are casual workers from Khadi board. They are praying for the benefit in terms of the open the case by the division bench and in terms of the finance department notification. Minimum pay scale. Last order, Lordship say, that the finance department has submitted that there no proposal has been sent by the Khadi board. My learned friend is appearing. I'm told that the proposal has been sent in the year 2019 itself.
I'm giving the.
Rajiv. But Mr. Hazarika, there are other issues
My lord.
which arise, although I have also passed orders for extending benefit of the decision of this Upen Das. But on retrospection, two things have come to our notice. Number one, this case of Upen Das was decided on the basis of a concession given by the government advocates.
Yes.
That's number one. Second is that the same was based on the government approval and a cabinet decision, I think. Now, once it is a cabinet decision, then you will have to also tell us how and in what manner a judicial order can be given to the government to act in accordance with the orders of the court.
Well,
Although nobody is objecting till date,
Yes,
but it's a legal question which has arisen, although in connection with another matter we've dealt with, but it's a question of principle of law. Because the court cannot issue a direction on the cabinet.
Two notification has been published by the finance department. Lordship will see page,
No, what they are doing in their own end is different thing.
my lord.
But you have to tell us the power of the court to issue a direction to the state government to implement an order of Upen Das, which was passed under circumstances which are totally in a different footing based on these two things which I am sharing with you.
I am praying in terms of the notification at page 47 at annex 7.
47.
Page 47. my lord. The finance department earlier issued a notification at page 45. It subsequently in superstition of this notification, page 47. They have issued a notification.
Okay, this is the, if this is the case,
My
if
lord.
47 is your case,
Madam.
then you have to tell us how this would be applicable on the corporation.
My lord, my primary contention is that the appointment in the Khadi board, it is in the approval of the finance department. And the rule 33 of the rule says, my lord, ordinarily the same kind, for same kind of work, my lord, similar pay scale to be introduced to the Khadi board, my lord. Along with the other,
So Khadi board is only a board, it's not a department.
my lord.
It's
my
not a departmental.
Understand is that with the approval of the parent department of handloom and textile, that can be done, my lord. Board has taken this stand. Now let them respond the textile, handloom and textile department and finance, my lord. They have not filed any affidavit in this case, my lord.
They are saying that they have now produced in 2019. What has happened to this after that?
Well-
What has happened after this 2019 letter?
And that till now it is not been effective. Probably finance have not received it.
No, first of all, the commissioner of the handloom and textile department will have to send it to finance.
Yes, my lord.
My lord, I will take an instruction. Just I have come to know about this document now only, my lord. I will take an instruction as to whether any steps has been taken by the commissioner, secretary of handloom and textile. They must have, my lord, I don't know, but since just now I have come to know about this. Otherwise, even my lord, exactly, my lord, I am in the same footing, my lord, that as to they are not government employees. That is what I was telling
You are
my friend.
changing colors.
No, and
With the mood of the court, you are changing colors.
No.
no, my lord, I have judgments even to support this. I have carried those judgments.
You're
my
carrying
lord.
those judgments also.
But
Okay,
ru-
very good.
Rule 33 of the board says, my lord,
My lord,
they are at par with the other government employees for the similar
See,
work.
supposing let us say that after my retirement, I open an organization.
My lord.
I float a company, I start a partnership firm. And then I say that the organization shall be equivalent to the so-and-so institute of the government of India.
That is true, my lord. Let
Let
them
us say
file an
I take
affidavit.
that resolution.
Let them file
I-
an affidavit, my lord.
Since I am
that
opening
is
it,
just-
I have a huge ego problem. So I say that no, this organization should be equivalent to so-and-so central government organization. Will not make it so.
Yes.
It will be the concerned department who will have to accept that.
My lord. Since the proposal has been sent to the
So we are
yes,
joining it, but these
department,
questions
they
will come to
take
you,
a
be
stand, my
prepared. If I am to hear the matter, these are the questions which will come.
So ratification will assume significance. That does, whatever, because board is a separate juristic entity. Now they are admittedly not employees of the government. Now in Upen Das, the dictum was, my lord, with regard to employees of the government. And even that notification which lordship has seen now at page 47, it only deals with, my lord, the government employee.
No, there is a judicial pronouncement by this bench.
yes,
I dealt with this issue.
yes, my lord.
It is
the
happening, my lord,
WPT
with, PNRD department. Yes.
Rajkumar Kachari case,
Yes.
my lord.
I'm aware.
Rajkumar
That's
Kachari.
why,
Yes.
in connection with another determination, this came to our notice again. Then these are the questions which come
Ra-
to,
Rajkumar Kachari, my lord, that case. My lord.
whatever it is, but be prepared.
Because that ratification part, perhaps he will have to satisfy.
No, but
Unless there
we
is-
have been passing orders, but this has come to my
Yes,
notice
yes.
because of another determination where this issue was raised. Whether it is permissible for a court to issue a direction based on the concession given by the law officer of the state in one case. This is backed by a cabinet decision, because it would amount to, whether it would amount to judicial order on the state to act in a particular manner. This, Hazarika, please prepare, be prepared. Okay, next panel. But Mr. P. Hazarika and counsel for the petitioners. First off, Mr. P. K. Murit, standing counsel for the
Respondent 3 and 4.
respondent numbers 3 and 4 has produced a scanned copy of letter dated 30/12/2019 issued by the Chief Executive Officer to the Commissioner Secretary to the Government of Assam, Handloom, Textiles and Sericulture Department. For regularization of service of the 35 numbers of casual workers, list of which was enclosed thereto.
Petitioner's names, my lord, will lordship will find.
Yes, there.
4, 5,
8, 9, 8, 10 and 11.
Okay, the name of the petitioners appear at serial number
4, 5, 8, 10 and 11.
next panel. No, not next panel, continue. It is submitted that the respondent numbers, you are 3 and 4.
3 and 4, my lord.
3 and 4 do not have any information as to how this request was processed. Next para. On a query of the court, Mr. R. Dhawal is standing counsel for the Handloom, Textiles and Sericulture Department.
One. So number
Has
1, my lord.
prayed, respondent number 1 has prayed for some time to obtain instructions. Just let a copy thereof be provided to the learned counsel for respondent number 1, just to enable him to obtain instructions. Next panel. Star Bortuzar, learned standing counsel for the finance department, is present. And he submits that he would also try to obtain instructions as to whether the finance department is in receipt of any such proposal.
After updating instruction is that we have not received any book as on today.
Okay. So how he submits that as on today, he has specific instructions that no such proposal has been received by the finance department. Next para.
From the handloom and textile department.
Asha, it's from the handloom handloom textiles and sericulture department. Next para. List on. How much time? No, we are posting it after this vacation because we will not be able to handle so much matters before vacation. List on.
Any date?
17/7/2024. It's immediately after vacation.
17. Public.
Yes, Mr. Talukdar, your matter.
This is regarding pension, my lord. Accountant will return the pension file of the petitioner, my lord.
Okay.
And there is no file. And my lord, PWD filed an affidavit that there is no any concurrence of the finance department.
No, because the requirement was prior concurrence.
Lordship, two hurdles are there, Lordship. One is Upendra's judgment is there. After 2017, Lordship, nobody can be regularized. That is one. And second, Lordship, finance department's approval was not there.
And thirdly, Lordship, what is most Lordship, may kindly see the proposal, who sent the proposal to the Accountant General, Lordship? The concerned executive engineer himself.
Where is that?
It should have been in the writ petition, Lord.
No, where is that document?
Arreta file, Arreta file.
The pension proposal will go from the head of the department.
Yes, Lord. It was moved by the concerned executive engineer himself, Lordship. In the writ petition itself, Lordship, may kindly see page.
Which page I have missed it. In fact, I don't study so hard.
Page 31, Annex 3.
31. This will never be processed. This will never be processed.
I have filed my affidavit, and there we have stated that no finance concurrence was there, Lordship, while regularizing the service of the petitioner. So in my understanding, Lordship, it's an unauthorized regularization, Lordship. So he should not get any benefit of a regular employee, Lordship.
Your affidavit, is it there? We don't find your affidavit. You find an affidavit by respondent number 2. Who is respondent number 2?
He is the chief engineer, Lordship.
Chief engineer. Oh, acha. Okay. Okay, you're appearing as PWD counsel.
Standing counsel.
Oh, acha. Okay, I was under the impression that you are appearing for the finance, so that's why.
No, no.
Yes.
Lordship, my senior colleague is also there, Lanet. He appears for AG, Lordship. We can also throw light on this issue, Lordship, whether executive engineer himself can submit a proposal for pension on.
Okay.
Mr. S.K. Medi is appearing.
Okay.
Regarding that point, I also clarify because I'm defending our pension. These all pension papers supposed to go by this one government.
By the head of the department.
That is the government, not by when chief engineer, it is to go by government, from
Head of the
government. That is
department.
my experiences.
So there is the law.
Yeah.
in effect. But thank you for that information.
That's obliged.
Yes, Mr. Talukdar. What do you say?
That is not fault of the petitioner, ma'am. He was working since 85. He was working as a mechanical. Boxers.
There is the order of regularization.
This 30.
Page
30.
20. 30.
Time penalty order dated 26. 26/4, madam.
No, this can't be answered. This question of the court cannot be answered. You see, Mr. Talukdar, the nature of inquiry we made right now during deliberations, there are two things. Number one, it is for the petitioner to show that the executive engineer had any power to regularize. That's first. Because then he'll be the appointing officer, appointing authority. Whether that is executive engineer can do it, we don't know. This one. There's a second issue that for the purpose of regularization, unless the file is moved through what is called FIU. What is that?
Otherwise also it's finance department, Lord.
No, finance, what is that?
SIU.
SIU.
Yes.
There's a prohibition for engaging any person on a permanent basis without the SIU approval. That is something which is evident from the OM, and a reference to that is also available in the judgment of this court. So financial concurrences is a must. Because otherwise what would happen is that anybody and everybody can appoint people, and the burden of the salary and other emoluments would fall on the state. This is the second part. The third thing is that the proposal of the pension was again forwarded by the executive engineer. I think it's the same person. Is it the same? Where's that finance proposal you showed me, Mr. Nayak?
30 is the regulation order, Lordship.
Yes, that's there.
And 31 is the submission of pension paper to the AG.
31. So it's the same officer. Same officer. Who's doing it. Therefore, the pension papers were returned. Now, without that concurrence, you have to show us what is the way to give you any relief. This question posed by order dated 26/4/2024 can only be answered thereafter. No, Mr. Targada, we'll have to dismiss your application. This is the thing we can't grant. I pass orders when I resume at 2.
Not today, my lord, any other date, my lord.
No. Once we spend our time, we are not. We can't
Because, my lord,
postpone the order.
how did poor petitioner will know that who will submit the pension paper?
No, that is
Why is
okay,
the
but
fault of
you
the
see,
petitioner?
you know, something in a very lighter note. I don't know whether this is an appropriate moment or not, but since you're saying that, in a very lighter note. I always tell, I have repeated this many times in this courtroom. You see, I went to a doctor. They examined me and then told me, sir, you don't have a heart. If I don't have a heart, I don't feel the, what do you call this? That empathy cannot be there if there is no order of regularization. The executive engineer does it. He does it at his own risk. At best, we can permit you to file a civil suit against the executive engineer who's misled you. Because this is something which can't be done. We can't burden the state because of a improper action of part of the executive engineer. So we can't help it. At 2 o'clock. Heard. Mr. P. Tarugdar, Learned Counsel for the petitioner. Also heard. Mr. P. Nayak, Learned Standing Counsel for the PWD. Representing respondent numbers 2, 4, 2 and 4. Ms. A. Talukdar, Learned Government Advocate, appearing for respondent number 1. Finance will be there. Finance, Mr. Gogoi. Finance, Mr. Gogoi.
Lordship,
Mr. B. Gogoi, Learned Standing Counsel for the Finance Department, representing respondent number 3. Accountant General.
3 and 6, Lordship.
Who was that? He was there.
Advocate General, S. Committee Junior was here.
Mr. S. Committee, Standing Counsel for the respondent number 5. Treasury Officer. Who
It is Finance, Lordship. B. Gogoi,
Finance,
3 and
sir.
7, 3 and 6, Lordship.
3 and 6 is Mr. Gogoi. Next paragraph. In brief, the case of the petitioner is that he was appointed as a work charged mechanical Jugali, Jugali, on 3/5/1985 in the establishment of the executive engineer, PWRD, Dhokwakana Territorial Road Division. Full stop. It is projected that the petitioner has completed more than 36 years of service without any break. Full stop. By an order dated 10/2/2022, passed by the executive engineer, PWRD, Dhokwakana Territorial Road Division, within bracket respondent number 4, the service of the petitioner was regularized for pensionary benefits. The said order was passed with reference to the government letter number FEB, is from 9/5/77/40, dated 6/3/1978. Full stop. The petitioner had retired on 28/2/2022 and submitted all his pension papers to the respondent number 4. The respondent number 4 by a letter dated 10/3/2022 forwarded the pension papers of the petitioner pension paper of the petitioner to the Accountant General within bracket A&E, Assam within bracket respondent number 5. Full stop. However, the respondent number 5 by letter dated 22/12/2022 returned the pension papers of the petitioner to the office of respondent number 4 with a query as to whether necessary concurrence of the finance department of the government has been obtained before regularization was not found mentioned. With further note that if concurrence of the government finance department has not been obtained, the case should be forwarded through the government. And in this regard, reference to OM dated 28/12/1999 issued by the finance department was referred to. Full stop. Accordingly, this petition has been filed under Article 226 of the Constitution of India for issuance of a direction upon the respondent authorities to release the pension and other pensionary benefits to the petitioner, as well as for quashing of the communication under memo dated 22/12/2022 issued by the respondent number 6. Next paragraph. The learned counsel for the petitioner has submitted that the respondent number 4 by an order dated 10/2/2022 had regularized the service of the petitioner. Accordingly, as a duly regularized government servant, comma, the petitioner would be entitled to all pension all pension and other retirement benefits. Next paragraph. Third contract, comma, the Learned Standing Council for the PWD has submitted that the executive engineer PWRD Dhokhakhana Territorial Road Division is not an empowered government official to pass any orders for regularization of service. First of all, we submit that due conference of the finance department is required as a condition precedent for regularization of service. First of all, in this regard, by referring to statement made in paragraph 5 of the affidavit in opposition filed by respondent number 2, it is submitted that in this case there was no concurrence from the finance department in the name of the petitioner for regularization of service. Next one. The Learned Standing Council for the finance department, for the accountant general, within bracket respondent number 6, has submitted that unless there is due compliance of the requisite formalities backed by the previous consent of the finance department, comma, the proposal of pension cannot be examined by the respondent number 6. It is also submitted that the pension proposal is required to be forwarded by the government, by the appropriate government, and not by the executive engineer or PWRD. The Standing Council for the finance department has also submitted that the previous or the prior concurrence of the finance department was not taken before the respondent number 5 passed an order dated 10/2/2022 for regularization of service of the petitioner. So it is also submitted that as per instructions received by him, as per written instructions received by him, comma, in view of the law laid down by this court in the case of State of Assam versus Upendas and others, comma, WA 45 of 2014, comma, decided on 8/6/2017, comma, owing to the restriction imposed on the process of regularization, comma, the state respondents It may not be possible for the state respondents to implement the to process the regularization of the petitioner. Next paragraph. In response to the stand taken by the Senate Departmental Council, the learned counsel for the petitioner has submitted that the petitioner is not in fault with in the manner in which the regularization order of the petitioner was issued. Therefore, it is something that notwithstanding like there may be some irregularity in the process, but as his service has been regularized by the hearing before effort order dated 10 to 2022, the petitioner is entitled to pension and other retirement benefits. Next paragraph. Upon consideration of the matters in the entirety, the court is inclined to accept the submissions made by the London Standing Council for the PWD to the effect that PWD as well as the Finance Department that without prior concurrence of the Finance Department, it was beyond the competence of the Executive Engineer, PWRD, Dokwakhana Territorial Road Division within bracket respondent number 4 to issue an order of regularization of service. Full stop. Therefore, such an order of regularization of service which was passed without taking note of the decision of the Supreme Court of India in the case of Secretary of State of Karnataka versus Uma Devi, 1996 for SCC page 1, as well as the case of Upen Das within bracket Supra. The order dated order under memo number page 30, like dated 10 to 2022 would not confer any right on the petitioner to claim pension or other retirement benefits. Full stop. Next paragraph. Moreover, the Learned Counsel for respondent number 6 has been able to dispel has been able to bring home the point that the pension papers are required to be sent to the Office of the Accountant General within bracket A&E, bracket of Assam, only by the government, and that the Executive Engineer, PWRD within bracket respondent number 4 did not have the competence to forward the pension papers of the petitioner. Next paragraph. Therefore, on the basis of the legal position as it stands on date, comma, the court is unable to take cognizance of the promotional order dated 10/2/2022, so as to entitle the petition to any relief. Next paragraph. However, under this, Pentas, what is your current stand that you are giving certain benefits, terminal benefits or something you are giving to the,
In the meantime, he has retired, Lordship. And he was works as an employee, Lordship. Otherwise, also he was getting scale pay, Lordship. Unlike Master Lordship.
okay, so he's not entitled to any other,
benefit.
okay.
Gratuity he will get, Lordship. That must have, if AG rejects the pension proposal, then it will be allowed to him, Lordship. Gratuity.
Pardon me,
Gratuity he is entitled, Lordship.
he'll be entitled to
If
gratuity.
when the AG will reject the pension proposal, AG will automatically allow him the gratuity, Lordship. That's it.
Okay. No, but this, unless he gets the pension papers, he will not do that also. So therefore, we have to,
They are even without regularization, Lordship, they get gratuity in the, they are.
no, I'm not on that. What I'm asking you is that the pension papers, you say that executive engineer could not have sent.
Yes,
Therefore, the government will have to send it, then the registration will come,
as regard other benefits.
as regard other benefits. Therefore, come on. Because it appears from the deliberations made at the bar that once the petitioner is not found entitled to pension and the proposal is rejected by the accountant general within bracket A and E, that was Assam, comma, the petitioner being a casual worker would become entitled to payment of
If
Gratuity.
any other benefits.
gratuity or any other benefit. Full stop. Therefore, comma, the executive engineer, PWRD, comma, Dhokakana territorial subdivision, road subdivision, is directed to send the pension proposal to the appropriate government, so as to enable the competent authority to resubmit the pension proposal to the Office of the Accountant General, within bracket A and E.
Lordship may not use that pension proposal, Lordship. For just proposal will do, Lordship.
Only proposal, okay, proposal. Appropriate proposal. Full stop. In the event the competent authorities do not find the petitioner to be entitled to a regular pension, comma, then the competent authorities would be required to process and grant any other financial relief to which the petitioner would otherwise be found entitled to.
Lordship.
Full stop. It is hoped that the entire exercise shall be carried out within an outer period of 3 months from the date of receipt of a certified copy of this order. So, proceed observations. Having found that the petitioners not otherwise entitled to the pensionary benefits, comma, this petition stands closed. This document you can take back. 22
22.
Please, adjustment delay regarding delay. That's 2022, 22 SC 503. 22 SC 503. Para 7 Lordship.
SCC 503.
503. The judgment says that there is
This one.
para 7. May I read, Lordship?
Yes.
From the aforesaid, it can be seen that there is no fault or delay or negligence of the part of the applicant at all. He was fulfilling all the conditions for the appointment of the compensation ground under the 1919 rules. For the reason his application was kept.
What is the name of the parties? We are not getting it. 2020 Volume 2 SCC 503.
Malaya Nanda Setti, state of Malaya Nandi.
Malaya, what is the spelling?
Malaya Nanda Setti. Nanda.
Okay, I'll examine this and pass others. Yes, what do you have to say?
My lordship can look into the page 25.
Yes.
Page 25, 8th column, whether applied within 1 year. No. Fourth column, name of the disease, date of the death, date of retirement. Date of submission of the application, 1/12/2017.
Yes.
My lord, and after my lord lapse, that the Honorable Supreme Court has already decided the issue regarding my lord, delay in my lord, submission of application and consideration of application. And
He
it
has
is,
brought out a better decision.
my lord,
He has brought out a better decision.
I had not looked into that.
Yes.
Lord, that judgment is there, my lord. In 2023, Supreme Court decided that issue regarding the appointment. Appointment on compassionate ground is not a source of income. It is only to assist the family during the distress time, my lord. At the father of my lord, the father of the petition, mother of the petitioner died in 2015. Now, my lord, almost 9 years has already elapsed, my lord. At this, my lord, after 9 years, my lord, whether requirement of the appointment on compassionate ground, my lord, arise or not, my lord, that is the point, my lord, that is most.
Yes. Mr. Knapp, these are the things which are coming out.
Correct. Correct. On the other day also. Yes, I come. No, no, it is said.
Because even today morning I said that to overcome it with the direction of payment of cost would be too high on the state.
Well, that is one.
Thousands of cases are coming in.
Correct. So from our side, we have also taken up the matter, but we are also looking to the thing. Ultimately, we will come up with.
2 years is possible. In the Oshut Das case also, my lord, this honorable court held that if the application of eligible candidates remain pending and cannot be considered due to want of vacancies for a period of 2 years from the date of making such application, all such application will require no further consideration must be understood to have spent their funds.
But my application was considered, duly considered, lordship.
Okay. Yes, Mr. Naik.
Yeah.
Same thing. Okay. I pass orders in chambers. Let me examine this judgment. But you've done well.
Okay. Give us the citation also so that we can also go through.
Oh, yes, yes. He's given a citation of AR 2022 SC 2836.
Right now, these are 2038. CPL appeal number 103.
Okay, I hope you have a good future.
Deeply obliged.
What happens in the case, I don't know, but I can always wish for your good future.
Twenty-seven,
Wait, please, your lordship. I apologize, your lordship. There is an error in the affidavit, your lordship. I'll have to rectify it, your lordship. It's a typographical error, your lordship. At page number 151. That's an error, your lordship. I apologize for that, your lordship.
Page number?
151, your lordship. It's an apparent error, your lordship, and we'll have to rectify it, your lordship. It's typographical error. I'm extremely sorry, your lordship. I
No, no.
apologize for it, your lordship.
I think you have to rectify your pages also.
Yes, your lordship.
One 51.
Yes, your lordship, 151. Running page, your lordship. Of my affidavit.
No, there's something wrong.
Page,
Please-
yeah, I will do it. I will
No,
rectify
no,
everything.
no, you check this and rectify.
Yes, your lordship.
The additional affidavit of the writ petitioner is page 102 to 131. Please rectify it.
I will. your lordship.
Additional affidavit of the petitioner is 102 to 131. Additional affidavit by petitioner. One affidavit is page 132 to 156. Second affidavit. No, sorry, affidavit in opposition by respondent number 1367 of 13.5. One is 157 to 163. The other is 164 to 169.
I will check it, your lordship. I will
Please
check and.
check and do accordingly.
Definitely, deeply obliged.
So this, how much time would you need?
A week, your lordship. Next week, your lordship will be listed.
Okay.
Next week regarding the and also the current status and what happened to these developments. Because they have already written and sent our proposed VRS proposal. So let them get the instruction what happened thereafter.
Definitely, I will.
Heard. Mr. A. Bhattacharya and counsel for the petitioner. Next, para.
I
Mr.
attempt for RS Dewry, your lordship. T Dewry.
Mr. T. Deori and counsel appearing on behalf of Ms. R. S. Deori, counsel for the
Respondent number 1, 3, 6, and
for
7.
the respondent numbers 1, 3, 6, and 7. I submitted that there's notice an error in the affidavit in opposition, and therefore place was obtained to take remedial steps. To stop. You're also there?
My lord, I'm
Ms.
first went
MD, Mrs. MD Bharat and standing also for
Public enterprise.
public enterprises. Is present. List on, give a date after a week. When, Mr. Deori?
Fourteenth, your lordship. June 14.
Okay, 14 June.
Deeply obliged, your lordship. Awesome.
What is this IA for? What is this IA for? Include this is IA pending in the matter. IA 1487, what is it for?
Sorry to answer.
Sir, in that other copy also has the standing counsel for the respondent was 1, 3, 6, and 7 shall also inform the court about the current status of the proposal of the petitioners.
What is your?
What is the prayer here? Compliance of order of 29 about to inquire about merging of the public enterprise.
Is, your lordship is filed by the petitioner, no, isn't it? With respect to the merging of the public interest department, your lordship, with the industry and commerce department and with immediate effect. Is paid for amendment, your lordship.
No.
Well,
Actually, amendment is required to be made.
Oh, to be newly engaged meeting.
No, because
With respect to an amendment, your lordship.
no, unless the amendment is told, we can't allow that in this manner.
Yes, your lordship. True.
Mr. Parasaji?
Well, I'm very newly engaged, so I'm not in a position right now to say, but I'll check.
No, because you see, this is about the merging of public sector enterprises which was being referred to.
Yes, your lordship.
So once that is there, you have to amend your petition accordingly. But for amending, you will have to tell us what you're trying to amend. This IA in this manner cannot be allowed.
No, it cannot be managed. I'll not press. If required, I'll file a.
In this IA, right? Mr. Parasaji and counsel for the applicant submits that he may be permitted to some time to obtain instructions and to take appropriate steps. First of all. Present. Madison is John today. We consider on the next date of listing.
I'm the president.
Oh, yes, sir.
That's a fix.
Item 33.
Yes.
Lordship, we have filed our affidavit in this matter.
Of respondent number?
Lordship, respondent number 2.
That's number 3. Yes, number 3.
No, but you see,
Respondent number 2.
but you see, even if he's not, even if he's absent and you don't take steps to.
Detailed affidavit will be filed. It is the.
No, it is filed.
Oh.
They filed it. You see, your stand will not be admissible stand, even if he is absent.
Lordship.
Unless you treat that not in service, for whatever period he has served, he will get it. And if you have not passed any order for his unauthorized absence, it will be treated as on duty.
Lordship, the
It
thing
will
is
be
that,
treated on duty.
Lordship, he has, from 2002, he has been untraced. He
No,
has
that
remained
is okay,
untraced.
but if you don't take
action.
steps in that regard, you don't.
Lordship,
You don't terminate him, you don't treat that, we don't draw the DP and say that this
Yes, Lordship.
is unauthorized absence.
Lordship, the matter, the thing is, Lordship, his appointment was provisional, is temporary. And whether he has been regularized or not, that is to be ascertained, Lordship. And there is nothing on record to show that he has been regularized, only a statement that he has been regularized before his retirement. At this stage, Lordship, at the time of filing this affidavit, the department was examining the case of the petitioner. And Lordship, if it is deemed appropriate by Lordship, the matter may be closed by directing the respondents to.
No, those can't be, because once we pass an order, we determine his rights. You're not asking your authorities to do it.
Lordship.
Lordship is rightly been pointing out because if pension paper is sent also to us, then we'll be pointing out AG, say what manner that particular period is be treated. That question will come. Before that, suppose again returning, now itself again he has to come back. Now itself this question to
yes,
be settled. Because otherwise he has to come back again to this honorable court.
but then it multiplies. There's a direction, your authorities can't take a decision. You lay blame on
Yes.
one to or the other, then comes contempt petition.
Yes, I did. Moreover, they have
Then your officer will say that, okay, there's a contempt petition, now make payment.
in the meantime, your lordship have this one provisional pension. He'll be enjoying. Because that will be all problems will come up
You're
with
not
that.
thinking those things.
That's what manner. Department is the department to see. If somebody
Then
is absent, some notice is
lordship-
required to be, or some action is to be taken.
Filing for DP or.
Then lordship-
Whatever manner we,
Then
it
lordship,
it
we
will be
will,
treated.
will take instruction. What is the present status regarding the representation that has been submitted by the petitioner?
Nobody will be interested. Once you allow us to pass order for personal appearance on the next date, every instruction will come to you.
It is a fault of
You
department.
just permit us to pass an order,
Lordship, what has happened?
allowing for personal appearance of the officers, every information will come to you. But Mr. Sheikh, there is one permanent, one duty of yours to show how you were regularized. Unless you can show that your service has been regularized, the other issues will not come.
That paper is not available with me, madam.
That is lordship, the questionable lordship.
If that's not there,
And your lordship would be pleased to see the affidavit my learned friend submitted in June 2023. Now my lord again saying that instruction will be.
no, Mr. Sheikh, there's a reason for that. That's why we are not disposing of matters like that. You see, you will have to show that you are a permanent employee.
My lord.
Then only they will maintain it and they will then find out
In that
whether
case,
you
my
were
lord,
otherwise absent or not. For a unregularized staff, they
My
are not going to
appointment-
maintain register.
My appointment letter may be looked into, my lord, 16, page 16 to
Page?
20,
Page
page 16,
16.
16. my lord.
There's no doubt in that.
Persons are hereby provisionally appointed temporarily, subject to verification of their antecedents. And correct that. That I have completed 16 years of service without regularization. That cannot be, madam.
Oh. Hmm. Hmm.
It would be an illegal order.
My lord.
Deputy Commissioner can't appoint for the DRDO, DRDA. DRDA is under which department?
Lordship, PNRD department.
PNRD
PND.
department. Deputy Commissioner can't give an order of
Lordship.
appointment.
At the time of appointment, lordship, DRDA was an independent agency. It was not under the Panchayat department. The department was only a nodal department, and the scheme was under the central government. Lordship, the appointing authority was then the deputy
The
commissioner
Deputy Commissioner was.
for the petitioner's post. Lordship. It is a temporary post, lordship.
Equally say, before supervisor, there is no debate of proceeding. No time proceeding. You do it to already connected people have to hate of the already. You can do it.
You're appearing for DRDA?
No, yes, Lordship.
No.
It is now under Panchayat Department, Lordship.
Okay, for Panchayat.
Yes, Lordship.
No, please come to page 30 of the petition.
Lordship.
Now, his joining report is accepted by Deputy Director. Why would a Deputy Director accept a joining report of a temporary employee?
That is at page 30, man. That is the way.
Correct.
Yes.
This is one. Second is, you see, he says that he was appointed by the Deputy Commissioner in paragraph 3 of the writ petition. You come to your reply. paragraph 2, you don't say that his appointment was a temporary nature, that you don't say.
Lordship, from the appointment order itself, it specifies that his appointment is temporary.
But he's being given a scale. It is a scale payment unless it is by a special, like in this, Upendas we have directed to give a scale of pay, that has to be approved. In those days, there was no question of scale of pay to a temporary employee. We have now found that. '83, the government was never giving a scale pay to temporary employees. You better clarify, otherwise the next it will allow this repetition.
Lordship, let me get the instruction whether his services has been regularized and whether his
Question
representation.
is not, you have not denied. You see, you have nowhere denied. His statement in the repetition that in the last part of the repetition, he says that his service was regularized.
That I refer to page 45. Their affidavit in opposition, my lord, para 6 and 7.
Just a moment. You see, paragraph 14 is the statement in the repetition. These things you don't deny. Once you don't deny, why should the court give you liberty to make that examination? But then you will take this order as a handle and then do whatever you want.
Lordship, may grant us one reasonable opportunity, Lordship.
Just adjourn it for 10 days, you take a call.
Yes, Lordship.
You don't do anything. You don't make any observation in the order.
Lordship, moreover, the affidavit is not, has not been made parawise.
That's your responsibility. Why should we?
That's why, Lordship.
We
detailed
have any
affidavit is
grievance with
required.
that. You make things simpler for the court. Once it is no affidavit,
Yes, Lordship.
I
That's
can
the
fall
fault on
back
our
on
part.
my alma mater, which is order 625 CPC, and then go ahead. It saves my time, lot of time. If you don't say anything, I'll be rather happy. Why should I have a grievance? As a court, I don't have any grievance. You have filed an affidavit, that is good. Page 44, Mr. Sheikh, what you wanted to show?
My lord, page 45, my lord.
Yes.
Their affidavit in opposition. Here it is said, my lord, para 6. It was of June 2023, my lord, affidavit. And here it is said that examination needs some time to ascertain claims of the petitioner. Para 6, page 45. And para 7,
You ask your officer to be present. Next Friday, he'll be here. This deponent, Basavi Thakuria. Ask her to be personally present. He wanted time, we got more than a year. What did-
Lordship, if I may, Lordship, 10 days may be granted, we'll take the instruction and place it before the Lordship.
No, no. Why? Because you see, this amount to harassing the petitioner. You don't do your work and then you spend time at the cost of the petitioner. Why? You got 1 year's time. Next Friday, we ask your officer to be present. But Mr. M. A. Sheikh, learned counsel for the petitioner. Also heard Mr. C. Barwal, learned
For five.
standing counsel for respondent number 5. Mr. C.K.S. Barwal, learned government advocate, appearing for respondent number 6. Next, Mr.
U. Sharma.
U. Sharma, learned
Lordship, I am appearing on behalf of Mr. S. Datta.
learned counsel, appearing on behalf of Mr. S. Datta, learned standing counsel for PNRD department,
For 1, 2, 7, 8,
representing
and 9.
respondent numbers
1, 2, 7, 8, and 9.
1 to 7, 8, and 9. By referring to the statement made in paragraph 6 of the affidavit in opposition filed by respondent number 2, place for some more time to obtain instructions as to whether the petitioner has been found entitled to pension and other pensionary benefits. Next paragraph. Having noticed that the affidavit in opposition of respondent number 2 was filed on 19/6/2023, the respondent number 2 had got about a year's time to make the necessary inquiry. Therefore, the respondent number 2, I, the Joint Commissioner of Panchayat and Rural Development Department, Assam, is put to notice to provide instructions to the learned standing counsel on the statement made in paragraph 6 of the affidavit in opposition filed on 19/6/2023. The said authority is put to notice that if such instructions are not provided, in that event, the Joint Commissioner of Panchayat and Rural Development Department shall be personally present in court at 10:30 a.m. on the next date of listing, and be prepared to assist the standing counsel to respond to the court query. Next, the learned standing counsel for the PNRD department shall send a downloaded copy of this order to the respondent number 2 to bring this order to the notice of the said authority. Next, list on is 14/6/2024.
Obliged. Deeply obliged.
Adipur,
Oblige, Your Lordship.
May it please, Your Lordship.
Yes, Mr.
My
Bravo.
Lord, before I proceed, my Lord, just want to make a small request, my Lord. Item number 34, 35, and 36 are all analogous matters pertaining to the same subject matter, my Lord. So I would humbly request, my Lord, because in item number 35, the affidavits have been filed, my Lord. So if Your Lordship may kindly take the trouble to take up item number 35, my Lord.
My lord, I have filed affidavit in item number 35, my lord, the stand of the board, my lord, SEBA. And the affidavit may be treated as common affidavit in all the matters.
Got it.
In brief, my lord, the matter
Just,
pertains.
just a moment. Yes.
My lord, may I take my lord to repetition 2831 of 2023, item number 35?
Yes.
My lord. My lord, the brief, my lord, the factual background is that, my lord, these petitioners are aspiring candidates, my lord, belonging to reserve category. And they have participated in a recruitment process in pursuant to an advertisement dated 25/03/2022, issued by the, my lord, state level, my lord, recruitment commission, my lord. Now, this commission has been specially formulated and constituted in pursuant to an act, my lord. Now, that act is quite relevant and rules, my lord. Now, that act is called, my lord, Assam Direct Recruitment Commissions for Analogous Posts in Class 3 and Class 4 2021. My lord. Now, they are basically my lord, a child of this particular act, in which, my lord, the rules promulgate certain procedure to be followed while conducting this examination, my lord. Now, my lord, the petitioners have qualified and have, my lord, done well in the first stage of the recruitment process, that is the written test, having, my lord, 175 marks in total of multiple choice questions, my lord. So after qualifying the first stage, my lord, they will all to appear at the second stage. Now, in the second stage, my lord, the examination is basically computer test or interview. So a computer test is mostly held in all the cases, my lord, for 3 categories of posts, my lord. Now, these posts are defined, my lord. I'll come to what are these posts, my lord. Now, these petitioners were all of them were called to appear at the second stage of the examination also, my lord. Now, in between, the respondent commission had, my lord, published a notification showing there what are the cutoff marks in each category, that is scheduled caste, scheduled tribe, my lord, in each category. So having qualified and securing more than the cutoff marks, the petitioners were called for the second stage, that is the computer test, my lord. Now, they appeared on the scheduled dates. They, my lord, they have done fairly well in the second stage, my lord, and they were expecting that the merit list would be published by the commission, because the rule mandates that a merit list has to be published before declaring the results, my lord. Now, my lord, what happened? These petitioners were neither given or informed regarding how much they have secured as in their first stage of the recruitment process, nor they were informed that how much they have secured at the second stage. And an impugned communication was emailed to them saying that they are not qualified, my lord. Meaning that, my lord, by a simple notification, they were informed that you are not qualified. So we, the petitioners, being aggrieved by the fact that they have not followed the mandate of the rules, including, my lord, the procedure which is prescribed under Rule 12, 13, and 14, my lord, which I'll come shortly, they have basically rejected the candidature, my lord. All that we are seeking before this court, my lord, is that we as a candidate have the right to know how much we have secured in the examination in the first and the second stage. Second, my lord, that whether our marks are, if we compare with the merit list,
more than the last candidate who has been selected or appointed in each category, my lord. So applications under right to informations were also filed, my lord, and some informations were given, but the most fundamental informations, my lord, relating to how much I have scored in the entire examination and what is the merit position in this examination has not been disclosed yet, my lord. And now, my lord, they are showing, my lord, this Board of Secondary Education in their affidavit has admitted that they have conducted the written test, but now they are throwing the ball on the court of the, my lord, state level recruitment commission that we do not have the documents pertaining to the second stage, that is computer exam, my lord. Now, the board will have to show or file an affidavit or produce the contemporaneous records, my lord, and satisfy your lordship that why they have not published the merit list. And if at all, my lord, then let them produce their merit list. And also, my lord, how much marks we have secured in this exam, my lord. So in brief, my lord, this is the background of the case, my lord. In case of each of these petitioners, my lord. Now, my lord, may kindly come to the rejection letter just at page 96, my lord. This rejection letter, I would like to bring it to the notice of your lordship, my lord. Page 96, my lord. Now, my lord, this is the intimation which was given to us. The last column, my lord, it says results not qualified. Before that, my lord, may kindly come at page 95, my lord. They have given the cutoff marks. Cutoff marks of the candidates for the next test, my lord, it says that is for the stage number 2. For the current petitioners, they fall under the category of scheduled caste women, my lord. For paper 3, the cutoff is 105 and paper 4, 124 and 99. So as we were called at the second stage, my lord, which would be evident from page 94, my lord, the petitioners have qualified the first stage, my lord. At page 94 is their admit card calling them to appear at the second stage, my lord. Admit card for recruitment of class 3 posts under Government of Assam for the next level of test, my lord. Post is bachelor degree with computer and computer test details are given, my lord. Assam Engineering Institute, Shanmari, examination date is 26/12/2022, my lord. So I have appeared, but till date I have not been informed how much I have secured, what is the position in the merit list, and whether belonging to this reserve category, my lord, the candidates who were selected, whether they have secured more than me or they have secured less than what I have secured, my lord. There is a complete opaqueness, my lord, in this process, my lord. Coming to the rules, my lord, then your lordship may kindly see, may allow me to place this rule.
This is which department?
My lord, they have this common examination for all departments. This is class 3 post for all departments, my lord. According to the requirement, my lord, they will be placed. Total 13,000 and some odd posts were advertised, my lord, all over Assam.
But this examination was done by
the state level recruitment commission.
State level recruitment commission. Who's appearing for that?
May please your lordship, I am appearing on behalf of B. Chaudhary, Standing Counsel SLRC, my lord. Due to some personal difficulties, he had left the court early, my lord. May I pray for 2 weeks' time to obtain our instructions, my lord, in this matter, my lord.
After so much of hearing, you are wanting time.
My lord.
But this,
my lord,
what you call the performance, every candidate will have a right to know the performance.
Yes, my lord.
That you can't deny. The stand of the SEBA is that they were the conducting authority, therefore it's a property of yours
my lord.
Therefore, they have returned it to you. They don't have authority to dispose. That's the ground. And that's an acceptable ground. But once you are the recruiting authority,
My
you
lord,
have to dispose that.
my lord.
Not 2 weeks, we are fixing it next week. But then we are very close to vacations. We will not be able to give time for hearing.
Next week, my lord,
Next Friday.
next Friday.
Okay. Because last week we can't take up hearing.
My lord.
And then, of course, this matter would be postponed to after vacation. We don't want that. Give me time.
My lord, of course, my lord.
Heard. You see, all sides are represented. On the prayer made on behalf of Standing Council for
SLRC,
SL,
RC.
RT. Matters stands adjourned today. List on next Friday. 14/6.
May I just make a small prayer, my lord? If they are in a position to produce the contemporaneous records only in case of the petitioners, and if they have a merit list, my lord, that will suffice, my lord, I believe. Because if they are into filing an affidavit, my lord.
Please make a note. We are not passing any order, but you take that note.
My lord,
He requires his own marks and the marks of the last
Candidate selected.
candidate who secured admission. The learned standing council for the SLRC shall also procure the details of the marks obtained by the petitioners, as well as the marks obtained by the last selected candidate in a seal cover for the perusal of the court.
In each category, ma'am. Because in each category, because in this writ petition, they are OBC candidate, they are my lord, EWS candidate, they are SC candidates also. So these trees are my lord, only if they are able to produce the marks of these category candidates, it will be convenient for my lords.
Okay, you all belong to all categories,
My lord, we belong to EWS category, we belong to OBC, we belong to SC women and SC male.
Okay, just right, of category.
Scheduled caste, women, male, EWS, that is it's general, my lord, and OBC, my lord.
OBC.
This will suffice. I'm highly obliged, my lord, deeply obliged.
This year returning this gazette notification.
My lord can keep that copy.
We don't want to burden it.
Obliged.
What is
Similar
it?
orders will follow. my lord.
Same.
In 34, 35, and 36, my lord.
Same.
Same order.
Okay, same order.
Obliged, my lord. Deeply obliged.
What separate orders? No? I put separate orders.
Thirty-seven.
But this is identical issue, not for the amount, no. Now here lordship will find the impugned letter published in the website at page 25.
Is the same examination?
My lord. Same
Yes.
examination, sorry. Now here, my lord, lordship kindly see page 25. Only says not qualified. No reason, nothing.
Oh, but the names of the other council are not there. You did not ask them to wait. The names are not there in the cause list.
Lordship, in this matter, we have not been served with extra copies, so could not take an instruction.
No.
In that case, let it be on Friday, since identical issue. In the meantime, we will send our extra copy.
Mr. M. V. Mandal, the counsel for the petitioner is present. Ms. A. Talukdar, the government advocate, submits that she has not received extra copies and therefore there is no instructions in the matter. It is also submitted that the SLRC has a separate set of counsel. Accordingly, the Joint counsel for the petition shall also serve requisite extra copies of the petition to the standing counsel for the SLRC. Next list on make it Friday. Friday is 14 June 2024. The registry shall reflect the name of SC SLRC in the cause list while listing the matter. Next.
Deeply obliged, Lordship.
38 with 39.
Lordship, in this matter, the affidavit is ready, Lordship. Kindly allow me 2 weeks' time, Lordship.
After it is ready.
It's ready, Lordship. In 5525, Lordship, item 39.
You just have to make a request to the court. We'll have this. We'll ask your respondent number 2
Lordship.
to compel your officers to be present before you. Respondent number 2 is Director General of Police.
Lordship.
If somebody is not coming to you for signature,
No, Lordship. Actually, some oversight is also there. It is already prepared, Lordship. Day before yesterday when the matter was listed, Lordship.
I'm just trying to learn. I'm just trying to understand. If it is ready, what is the requirement of time?
No, Lordship, then I'll be sent it for vetting, Lordship. They have given us instruction. I accordingly prepared, Lordship.
Okay. Just a moment. Question of gradation list. Okay,
Lordship.
give them time.
My lord, the item number 30 is regarding, my lord, non-payment of, my lord, notional benefits, my lord.
No,
We-
just no, you're not into the matter. This
Here, affidavit is
item
required, Lordship.
30
Item
38.
38.
Yes,
38, 39 is same.
same, my lord. The challenge is different, my lord.
Challenge different, and here, Lordship, private respondents are also there in 39.
No, then 38 you.
39, my lord,
pass an order.
promotion list, my lord, private respondent. I have
Just wait, in 38 you pass an order. Both sides are represented on the pair made by Mrs. M. Bhattacharjee, Leonard, additional senior government advocate. List after 2 weeks, so as to enable her to file affidavit in opposition in the matter. Then 39. What is there?
In 39, my lord, the promotion has been given, my lord, some of the junior candidates, my lord. That promotion we have challenged, my lord.
But it's already interim order operating.
Yes, my lord,
Lordship.
10 posts.
Yes, this has been directed to be kept vacant, Lordship. This was there, this has been complied.
It is order dated, my lord, 19/9/2023, my lord. Page 104 is the, my lord, impugn order. They are the, my lord, 58 beds, my lord, who are promoted by them. My lord, I am the 49 beds. my lord.
Counsel for the petitioner and the then additional senior government advocate are present. Next paragraph. As per office note dated 31/5/2024, service of notice on the respondents number 8 is awaited. Full stop. This after the ensuing vacation. Summer vacation. Along with the office note as regards service of notice on respondent number 8. Interim order passed release and is extended till the next date of listing. Next paragraph. On the next date, the learned counsel for the petitioner is permitted to renew the prayer for tagging this writ petition along with connected WBC 3835 of 2023. Your service is not complete.
My lord, flag X is the, my lord, the tracking report, my lord. Flag X is the tracking report upon the respond number 8, my lord. My lord, in the last occasion has directed to submit the tracking report in respect of this
Okay.
respond number 8, my lord. It shows item delivered, my lord.
Others delivered. All delivered.
Okay. Okay, then don't strike that out. You say that present, next paragraph. The learned counsel for the petitioner is referred to the postal track report.
40 per head. इसके बाद वो
produced, which indicates that the postal article was delivered to the addressee on 3/6/2024. Stop. Therefore, notice the DMT will duly served on respondent number 6. Stop. Non-appears on call for respondent number 6. Yes, then what?
Number 8, this.
Oh, number 8, not 6, 8. Yes, then what?
My lord, others are already, my lord.
No, this
All service complete, my lord.
okay. Interim order passed release and is extended to the next date of listing. List after 2 weeks.
My lord, for the affidavit is given, may be given as a last chance, my lord. That can be recorded.
We'll give it now.
Yes, Lordship, there is nothing to be last chance, Lordship.
He says that he's ready, then
In the last order, my lord, it was said, my lord, it needs to be filed, my lord, before 2 days of this. 8/5.
do it. because
Yes,
otherwise
yes,
they-
Lordship.
things-
Will be.
I'm deeply obliged.
Deeply obliged. The date fix was-
40.
May I please, Your Lordship? I'm appearing on behalf of SC Viswas. Kindly, this matter may be adjourned for a day, Lordship.
Just a moment.
Last order to us.
Yes, I'm not being able to follow it. There's an order here, judicial order, saying that the order of the coordinated bench in WPC 2990 was to be complied with. Where is that? Compliance?
Compliance is hit on hold on. Suppose Two double nine zero 2017. Lordship, thing is that in 2990 2017, as per the last order, court was reluctant to give regularization, Lordship. And after that, the doors of the court was been opened to him that if he want to get a pair for this thing is there, the pay, Lordship, then he can again approach the court. So, Lordship, in our affidavit, Lordship, it has been mentioned that the basic minimum basic pay as per the approval of the finance is already getting, Lordship. So, yes. So minimum basic pay, Lordship, he is already getting, and his appointment was purely temporary basis, Lordship. So,
You filed your affidavit with that effect?
Lordship, we have filed the affidavit. In fact, in the last order also, it has been reflected.
No, this way, because this order 2990 is not here. So what is that order?
2990.
The order.
They already been annexed in the requisition.
It's next in the rate petition. Okay, where is that? Which page?
46 actually.
So, copy to the.
Okay.
Also copy to numbers.
No, but this order is not that. This order says that by his long service, he is already a permanent employee.
Lordship.
Therefore, you have to comply with this order. You have no choice but to comply with this order. You did not file any appeal against the order of order passed in 2990. The question of minimum skill pay will not come. He will be getting a full salary as a regular employee.
Lordship, in this regard, then Lordship, some recommendation will be given to me. Yes, sir. Order to give.
Your name?
Larry Anthan.
K. Anthar, and counsel for the petitioner. On a query of the court as to whether directions issued by order dated 15/5/2024 directing the respondents to take steps to comply with the directions contained in the order dated 30/1/2023 passed in WPC 2990/2017. Mr. C.K. Barwar, a government advocate, has submitted that the petitioner is already getting the benefit of a fixed pay.
Minimum skill pay, Lordship.
Minimum skill pay.
As per the approval of the finance department.
Huh?
As per the approval of the finance department.
As per the approval of the finance department. And therefore, the petitioner is not entitled to any other relief. Next paragraph. The in this regard, the court is inclined to reproduce the relevant part of the hearing before referred order dated 30/1/2023. Quote from page 49. There's a red pencil mark, page 49. to page 50. Next paragraph. In this regard, the government advocates praise for is granted time to address the court. Matter stands adjourned today. List on 17/7/2024. You are also there?
I would respond about 2 laws.
Also right, okay, handy for respond, doing a standing council for respond number 4. And Mr. A. Fugan, then council for respond number 1. You are there? Okay.
One. Three, respondent.
Arthur Officer, standing council for respond number 3. Okay. Awesome. You said it doesn't help you, all 4 of you should, you'll have to take a call. All of 4 of you can sit together and take a call because there's already an order of the court. It has an effect. You can't wriggle out of that order. You examine that order and take steps.
41.
In this case, it's a case where a compulsory retirement has been imposed upon the petitioner. Well, the disciplinary authority has not filed the affidavit in spite of taking a lot of time. No. 1 and 2 has filed the affidavit, but the.
Affidavit 1 and 2 is there.
But it is the office of the senior government advocate who is the appointing authority. So we'll kindly give them a time frame or fix the matter for admission hearing, let them file the affidavit in the meantime. They can produce the records also.
One affidavit is filed with respect to 1 and 2.
It is the disciplinary authority. No.
Yes, Mr. Majumdar. Mr. Chaudhary is giving you 2 options.
To be very frank, well, I have not gone through the petition also. Let me go through, let me take it up in the
It's
next
a
week.
case, simple case where compulsory retirement has been.
Yes, yes, I've seen that one inquiry, some case, the charges were that some case diaries were received, but he didn't produce in the court. He took
No,
time.
that's okay, but
Right.
yes, Mr. Chaudhary is now giving you 2 options. Number 1, produce the records or file an affidavit.
I
Because
think
if
my
it is out of
learned friend is
service,
appearing for the perhaps.
if it is out of service,
They have filed the affidavit.
if the person is out of service, he'll be pressing hard.
Yes.
We take up for, we listed for admission on, we'll take it up after reopening. Mr. Chaudhary.
Fix a date in the
I'll-
meantime, let them file their affidavit.
I'll see if this file, if the filing of affidavit is required,
We are
I'll
giving
file,
you both
otherwise I'll
options.
produce the record. ma'am.
We're giving you both options.
Yes, yes, ma'am.
15th, we are reopening my.
In fact, we're making 19th.
कितने दिन? हाँ.
But Mr. Kane Chaudhary, London Senior Counsel, assisted by Mr. T. Deori, Counsel for the petitioner. He has submitted that as the petitioner has been
Compulsory.
he's been compulsory retired. There is some urgency in the matter. Next, Mrs. Amber Tesari, London Counsel for respondent 1 and 2 are present. You have for 1 and 2?
Lordship, I am assisting
Oh,
the
acha.
petitioner.
1 and 2, who's briefing? You only?
Yeah.
One and 2, I'm appealing. 1 and 2, I'm appealing.
One, okay. Did you say?
Sign number to by name.
By name.
Sign number to by name, Dipankar Babu.
Three, next to the senior government advocate.
But why you are implementing this
Yeah, I can appear.
number 4 by name inquiry officer is otherwise an officer of the court.
That can be deleted, man.
Or rather, instead of deleting, you can say, we strike out the name, let it be inquiry officer only.
Yes, only
Right.
as inquiry.
Okay.
Yes, without the name also, he can still, naturally has to be made a party.
Or in official capacity. Lordship,
As an inquiry officer.
yes, your lordship may indicate that so that otherwise there will be a question as to why he has not filed affidavit, whether he has entered appearance or not. Because
No, no.
it's by name.
Once we take notice of it.
My land.
You don't write like this. You start, have this a change of it. So that part you write, huh? The change of this is sufficient. Next part. It is noticed that the respondent number 4 has been added by name. Full stop. It appears appropriate to the court that by deleting the name of the person concerned as respondent number 4, the nomenclature of respondent number 4 should be only referable to the inquiry officer.
I think the.
Stop. According to the court, is inclined to direct the direct that the name of the respondent number 4 be deleted, and instead the the matter will proceed against the the inquiry officer.
But that's all.
Stop.
Extra copy.
Mr. T. Deori, Leonard, instructing counsel for the Leonard instructing counsel shall make necessary correction in the constantly in the presence of AOJ's civil rule pending section. So accordingly, accordingly
Respondent number 5. No.
and accordingly on the said correction being done, the central registry shall also be corrected. Next para. Mr. D. Mazumdar and additional senior government advocate, additional advocate general for the state, assisted by Ms. Bhattacharjee and senior additional senior government advocate. Prays for and granted time to examine as to whether whether any affidavit in opposition shall be filed by respondent number 3 and 4, or he would produce the or he would instruct the respondents for production of records. The prayer is allowed. List on 19/7/2024. Affidavit in opposition, if any, by the respondent numbers 3 and 4, be filed at least 2 days prior to the next date of listing. Give me. 32. Yes.
Lordship, here, the prisoner paid for the benefit, financial benefit under the scheme of the MACPS, my lord. But that has been denied, my lord. Now he has been retired from service, my lord. He has been retired on 31st of December 2023, my lord. What happened, my lord, in the year of 1998, my lord, initially he had joined in the post of the assistant academic officer in Seba, my lord. Lordship will find that at page 14 of my writ petition, my lord, annexure 1.
Just a moment. Okay, who's appearing for respondents?
No, we are.
You're there. You
We
filed
have
an
filed,
affidavit.
my lord,
Yes,
what is
they
it,
have
my lord?
filed affidavit, my lord.
We have filed affidavit, my lord.
My lord, in that
Petitioner, my lord, petitioner claim as per the notification, that notification is not annexed yet. Lordship may see the notification also, my lord, because without annexing the notification, how lordship will adjudicate the matter?
Moreover, my lord, on the basis of that notification, my lord, board has adopted any resolutions that, my lord, is a slab 10, 20 and 30 years. That has been board adopted at 12 years. 12 years because it is a board, he is an employee of board, not government employee. So government has issued this notification. That's why board has adopted this notifications, my lord, for these purposes, those who were continuing for 12 years. And counting the petitioners, my lord, retrospective effect cannot be given because he 14982, he was an academic officer. And then controller, then he switched over to the controller of examination on 1/8/2009. And thereafter academic officer, again, he started on 29/6/2012. So that cannot be a, my lord, 12 years. This notification is effect from 6 July 2017. As per this notification, they are claiming the one increment. This notification is not before your lordships. And also our resolution is not before your lordships.
This is answer 11.
No, but the good part is that you are also not annexed.
My lord?
The good part is that you are also not annexed. Because you are taking a plea that it is 12 years.
12 years.
So you are required to produce that.
The
That notification is there, my lord, in Annex 11.
resolution is there. Resolution is there. Resolution, board resolution before your lordships. Agenda 19.
Madam, what he has said, madam, my case is slightly different, madam.
Where is that? Where is that scheme?
The scheme lordship will find in at page 36, Annex 11 in my reply, my lord. Affidavit in reply, my lord.
Yes, sir. This notification closed.
No. I think if I understood Mr. Surya correctly, he's trying to say that this notification of 6 July 2017 is not applicable on the
Government.
Board of Secondary Education. He says that as per their resolution, this career progression scheme is 12 years. For direct recruit officers who have completed 12 years of continuous service,
Yes.
then he'll get a promotional benefit by financial increment.
He has not continued 12 years. He has not continued
No,
12 years.
my case is not that, my lord.
Huh?
What happened, my lord? Initially, I have joined as assistant academic officer in the year of 1998. Later on, my lord, in the year of 2009, my lord, the department has plotted an advertisement to fill up the post of the examination controller, my lord. I have submitted my application, my lord. They have accepted my application. Not only this is the open market interview, my lord, was held. The advertisement was published in the newspaper, my lord. And then, my lord, after getting the calling letter, I have appeared in the examination and I have been selected. I have joined. That is my direct appointment as the examination of controller. That post is higher grade than the assistant academic officer. After joining in my post, that is at page, my appointment letter at Annex 2, my lord, that has been issued in the year of 2009. I have joined in the post of examination of controller, my lord. That is the higher grader. Later on, my lord, what happened? When I have joined in the higher post, my lord, after getting the direct recruitment, I have relinquished my earlier post, my lord. Assistant academic officer. This is my entire service has been started from that year. That is 1/8/2009, my lord. And later on, what happened, my lord? As per their notification, my lord, they have changed my designation. I have been posted to another post, that is academic officer. That is similar grade to the examination of controller. And kindly turn to the next page 18, Annex 5, my lord. In the year of 2000, 12, my lord, I have been permanently absorbed as the academic officer, curriculum reform, Seva, in the same rank, salary, and status as he is enjoying. And that is remains same to till my retirement, my lord.
When did you superannuate?
31st December 2023, my lord.
2023.
That is, my lord, started in the year of 2009 to till my superannuation, my lord. And in their affidavit, my lord, they have issued a letter that is lordship will find at page 20, annexure 7. And the basis of that MSCPS or APCPS scheme, my lord, they have issued an order, my lord. That is kindly turn to page 20 of my writ petition, annexure 7, my lord. First point, for a direct recruited officer who have completed a 12 years of service, continuous service in the board, and if she has not received any promotion or financial increment during this tenure, then she will get the promotional benefit. My lord, my post is stagnant, my lord. There is no any promotional system, my lord. Therefore, I am entitled to get the increment, my lord. Third one, my lord. Nothing has been given. And as per the, my lord, as per the scheme, my lord, that scheme, my lord, lordship will find in my affidavit in reply, my lord. That is at page 36.
Yes.
Salient features of the scheme. Number 1, MSCPS would include grant of financial upgradation 3 times in the entire service period, whereas the completion of 10 years, 20 years, 30 years to those employees who do not get 1 regular promotion within the first 10 years or 2 regular promotion, ACPS benefit within 20 years of the promotion, ACPS benefit within 30 years of the regular service. Number 2, the MSCPS will provide only financial upgradation and shall not entail any change in the designation, place and nature of work, and change in the seniority of the persons concerned in the gradation list. And here, my lord, I have been posted in the various posts: examination controller, academic officer. My assistant academic officer, that post has been relinquished, my lord, after getting my higher grade. But till my retirement, since 2009, I have not been given any financial upgradation, my lord. And in their affidavit, they have taken the plea that I have acquired various posts. Therefore, I am not entitled to get the financial upgradation, my lord. My lord, kindly see their affidavit, my lord, paragraph 5, my lord, at page 29. Paragraph 5, my lord. Page 28, my lord, of their affidavit, my lord.
Yes.
I am reading, my lord, that with regard to the statement made in paragraph 4 of the writ petition, the deponent begs to state that the petitioner was initially appointed as the assistant academic officer. Later on, by office advertisement. I have annexed that advertisement in my reply, my lord. Followed by the interview, he was selected as a controller of examination. Accordingly, he joined in the new assignment. It is fact that though his pay of assistant academic officer was similar with the controller of examination, but these 2 posts are different cadre. As such, he is not considered for the benefit of MSCPS.
Exactly, the different.
My lord, assistant academic officer, that is another grade, my lord. I have not been promoted, my lord. I have get the next higher post by direct recruitment, my lord. After appearing in the interview, if suppose, my lord, that was not me, another person, he will not be entitled, my lord. I am not promoted, my lord. Number 2 is that, my lord, annexure, okay, paragraph 6, my lord. I am reading the in a regular part, my lord. Kindly see from the bottom 1, 2, 3, 4, 5, 6, 7, 7th line, my lord. As the petitioner did not continue his service in a single post, he has not come to the purview of the order. The petitioner was initially appointed as the assistant academic officer. Later on, by office advertisement, that is admitted fact, my lord. Followed by the interview, he was selected as the controller of examination, and accordingly he joined as the controller of examination, and later on his post was reorganized as an academic officer. As such, he got elevation from assistant academic officer to academic officer in his service career. My lord, here what happened, my lord, that is the same post, my lord, examination controller and the academic officer. There is the same grade, same cadre, same cadre, same salary, same scale pay, same everything is same, my lord. But name is different, my lord. But assistant academic officer, that is another grade, my lord. I have relinquished that post after getting this post. And what happened, my lord? Later on, my lord, they have reorganized this post. And in the year of 2012, my lord, I have been permanently absorbed in the post of academic officer. Therefore, my lord, since 2009, when I have been appointed as an examination of controller, and till my superannuation, my lord, I have not been financially upgraded, my lord. And
No, but you
MSCPS
see, we don't understand. You see, you come to page 22. 22 said that you are promoted to senior academic officer.
20.
Page 22 says that you have been promoted to senior academic officer. You've got that promotion.
She is a Ranjamani Mahanto, my lord. This is not for me, my lord.
This is not you.
No,
So why you
Ranjamani
understood
Mahanto, my
this
lord, similar to me, my lord.
She
But
has,
she has
the
been.
order says, Lordship, she has one completed 12 years of continuous service on 7/12/2022. The same post is promoted as senior academic officer with effect from.
Oh, she's not different person.
This is a different person.
Different person, my lord.
This has been
But
announced
then
only
it's
to
not-
say
it
that,
is-
my
yeah.
lord, she
Then-
got the benefit, my lord. She is junior to me, but I have not been given the
Petitioner case is
benefit.
not seemed like that. Background is that, my lord. Petitioner, he was at a controller of examination. There is some problem. He was again back to the academy officer, and DP was drawn, and he was delegated to the assistant academy officer. Lastly, he was again, they have considered academy officer. And your lordship kindly see, affidavit reply, my lordship kindly
No,
see.
something is wrong then.
No, my
Something
lord,
is
he
wrong.
was DP, lordship kindly page 36 of his affidavit reply. This is scheme. Scheme clause 7 says the financial benefit of the scheme shall be given with effect from only 1/1/2017. So otherwise he is not retrospectively entitled, my lord. And also, lordship kindly see page 38 last MSCP benefit, lordship kindly see. All the cases where the government servants have completed 10/20/30 years of service and have no DP or criminal case against them shall be shortlisted for MSCP benefit. It is another point. DP was, inquiry was made against him, my lord, because in the, he being academic officer, he my lord, did certain things. He said, Vishnu Rabha, who is Vishnu Rabha, so and so, that was an inquiry and the repercussion in the board. This scheme also, my lord, said this person cannot be also considered. And now he is a continuation of the academic officer, is not continuation. He come to the, my lord, the controller of examination. Thereafter, he was academic officer and delegated to assistant in between. Defined post, my lord, not same post. He's not entitled and he's not completed 12
You
years.
show from sequence what has happened. You are not, I'm not being able to follow you.
My lord, what happened? Petitioner not continuing with the same
No,
post.
no, I understand, but you have to substantiate with some document because I'm not being able to follow this story. You say that he has been, there was a DP and he was degraded. Where is that document to show?
That is that, of course, this is a breakdown. That is not, my lord, we have mentioned here.
Because he says that he has been, what you call, he was earlier.
He was academic officer.
No, he says that he was additional,
Controller of exams.
no, assistant.
Assistant academic officer.
Therefore, he participated in the recruitment process and was appointed as a academic officer. That's what he says.
No, controller of examination.
Controller of examination.
Controller of, so different post.
Post may be different, but he's a direct recruit. So what was his earlier post is not his concern.
Yes,
You forget that.
He's a direct recruitment. He's a fresh recruitment. So he's not continuing.
No. From that day, you continue 10 years or 12 years. Whether he has been given that MSCP, he gets it.
No, he thereafter he converted to the post of academic officer.
No, that is not his. It is not his asking. You appoint him to a post A. Then after a few days, you designate him to a post B. After some days, you designate him to post C. Is it his fault?
No, because due to his My lord, due to his wrong, my lord, he was against him, he was
No,
inquiry
he
was
may be
done.
wrong, he may be worst man in the.
Better, I will produce the record, my lord, lordship will
No,
see.
no. That's not the way. You see, he may be the worst man on the earth. But unless you draw a disciplinary proceeding and disentitle him to MSCP by inflicting a punishment,
It is
he
not-
remains in the same grade. He may be worst man.
It is
but
not a
after
punishment,
10,
my lord.
12 years, he gets his MSCP. That you can't deny.
Lordship kindly see, controller post is a higher post. And why he is degraded to the academic officer and then academic officer to the assistant academic officer, record is there, I will produce before lordship. He did not
Because that's
continue.
why we are not being able to follow you, but we are able to follow Mr. Barba's case.
Let me have the records, my lord, I will produce everything. Then the lordship will consider, my lord. And my lord, against him, my lord, inquiry was done, what he was done, my lord.
No, we don't know because there's no,
Nothing has been-
that part of the story is not even pleaded. And therefore, I am unable to follow you.
Next week, my lord, I will come along with the records, my lord.
Okay, give us a date.
June, Ajit, man. 16 July, my lord.
16 July is not next week. After vacation.
July, you are asking 1 month time.
Today's 7, 21, my lord. June.
My lord, that will be better than
21st
20,
June.
my lord.
No, 21st, because I am fixing many parted matters on those hearing days. Both sides are represented on the chair made by Mr. T.C. Goyal and his standing counsel for the secondary education department. List on 20.
Seba, my lord, not secondary.
Oh, sorry, Seba. List on 21/6/2024.
Obliged, my lord.
You take back your document, this resolution. Because this resolution is entered in that order.
Yes, yes, yes.
So therefore, he is not required to produce that resolution.
This ladies, my lord, she is entitled, that's why she was given.
No. This resolution is in form of an order is he has annexed.
Yes.
I will see, my lord.
Yeah.
Obliged,
This was a resolution of 22 and in 23 there is an order, office order. He has annexed that order.
I will see.
Obliged, your lordship.
43.
Make me look. In this case, my lord, steps on the respondent number 4 and 5, my lord, were taken on 29/1/2024, my lord. However, my lord, the service scope will not complete, my lord.
Just a moment. More than 5. You have to take steps.
My lord, please.
Mr. S. Hawk, counsel for the petitioner shall take note of the order dated 5/6/2024 passed in the proceedings of Lahozima Court and take appropriate steps for service of notice on respondent number 4 and 5. First of all, the list on, give a date after 5 weeks.
31/7. My lord.
Forty-four.
In this matter, my lord, 13/5/2024, there's a order. Order means, my lord, he made a party responsible 4/2/27. He does not know the address of the death. Then we are directed to, my lord, communicate it to the, all these things. We have communicated it, my lord. And accordingly, perhaps they are appearing.
I'm not sure. But Kugatama has got a file matter. I have instruction, my lord. I'll clear my.
Okay, that is okay, we don't need that.
Oh, no need, my lord.
Yes, sir, record-
Well, they accept
okay.
it, but they will receive it.
Mr. K. Vishwakarma, and the counsel for the petitioner is present. So Mr. T.C. Jithial, and additional senior government advocate has produced a copy of communication dated 27/5/2024, by which the
Private responsible 4/2/27 has been informed.
by which the private respondent numbers 4 to 27 were informed about the pendency of this writ petition. Full stop. The said communication is made a part of record. Next, para. Mr. P.P. Sinha, counsel for the Learned Counsel enters appearance for respondent numbers 4 to 27.
So that some of the respondent also given instruction to appear for the.
You are also there.
Yes.
Mr. B.P. Sinha, as well as Mr.
DK.
D.K. Roy, Learned counsel appears for respondent numbers 4 to 27. First off. So we take it up in the admission column.
May I please, till today, they have not filed any Ukaratoma, let it be till next month. They appear.
No, not that.
My lord, an affidavit has been filed from the respondent authority. I may be allowed to file the reply to that. my lord.
Okay, you're not filing an affidavit? No, okay.
Not the first time they are.
Mrs. You have filed your affidavit?
We have filed affidavit.
Okay,
My lord, we want to file reply to that, my lord.
you want to file an
Yes.
affidavit? Okay.
My lord, in the meanwhile, my lord, as per the order dated 8/2/24, my lord, I have prayed for the interim protection, my lord. I could not place it before this honorable court because the notice was not issued to the all the respondents, lordship. My lord, may if allow, I may be allowed to place for the interim protection, my lord.
What interim protection?
Or not to give effect to the final gradation list.
Yes, lord.
My lord, I have not gone through it, my lord.
My lord, there is a
This will be difficult. This is a, what you call this gradation list.
yes, lordship.
Is of 28/8/2023.
Yes, lordship.
Now we are about, how many months?
24.
8, 9, 10 months down the line.
Yes, lordship.
What has happened in the meanwhile?
My lord, there is, no, my lord. What happened is, my lord, before 1 year, my lord, this gradation lists are published. And if at all the vacancies are available, according to this gradation list, my lord, there will be recruitment on that basis. Promotion will be based on that, my lord. My lord,
I have been informed by the officer, my lord. Some of them, my lord, private respondent is going to be retired 1.5 month. After 1.5 months, 6 months, like that. At this stage, my lord, interim order is, my lord, it will hamper them.
my lord, we
Because,
have
my lord,
not-
gradation list, otherwise he is a senior, but definitely he will get it. Others are there, not all, my lord. Some of them, my lord,
So
retiring
I'm
after
asking
what
it
we.
because I have not been able to follow this, this gradation list. Yes, so-
The final gradation list
No,
that
no.
has been published, my lord, 76/2015.
No, this is,
Page
this
number
is,
82.
8/20/23.
Page number 82, my lord.
No,
Eight-
no,
8/27.
no, just on.
Yes.
You're trying to say that, once you are in the list,
Yes, Lordship.
in seniority, you are absorbed in the regular police force.
Yes,
That is your case.
yes, ma'am. My lord, when this particular organization was formed, my lord. at
No,
that-
instead of staying it, then we say that, if there is any superstition of the petition, that will be subject to further orders of the court. We are not staying it then.
My lord, I want to place something, lordship. This is a homework rules, lordship. My lord, there is a general procedure of promotion, my lord. I will straight away come to point number D, lordship. The committee shall prepare a select list in order of preference, and the total number of such names shall be equal to the number of vacancies that may arise in respect of the percentage allotted for the promotion quota in cadre and ex-cadre post of the rank during the period of approximately 1 year thereafter. In every case, while drawing up the list in the committee changes the order of seniority of any person in the rank of Subedar or supersedes anyone in that rank by omission of his name, the committees shall record in writing the reason for such change or supersession.
So where were you in the earlier position? Your earlier position is what? How is the position changed?
My lord, actually, there is a brief fact of the case that I have to state for that, my lord. Because my absorption was done by the order of this honorable court.
Correct.
When the order of this honorable court was done, my lord, the order says that on the month of 2000, on the year 2018, I have to be absorbed. Sorry, 2008, my lord, I have to be absorbed. That was the day when this particular organization was formed. My lord, at the initial stage, I was in the Assam tea plantation force. This was a force which was developed by the government of Assam to meet the requirement of the tea plantation at that period of time for fighting the extremity issue. Then, my lord, what happened is that since we were doing the same work as that of the Assam police, that is why we said that we want this similar equal pay. So accordingly, our organization, our welfare committee approached this honorable court by filing a civil rule, my lord. And after that, the honorable court observed that since the kind of duty we are doing, so we should be either absorb or rehabilitate somewhere else. So after this order, my lord, what happened is though there was no specific period fixed for that, my lord, but even though the order was passed.
That is 2014 judgment of the court.
2002 judgment, my lord.
2002, where is that?
My lord, may kindly come to page number 21. Of the relevant portion, if lordship may come to kindly page 27, my lord.
97 of that.
The fourth paragraph, my lord. Page number 27, fourth line.
Paragraph number?
Paragraph number 6, fourth line. Whatever the justifications and reason may have been, the fact remains that the members of the force under the direct operational and disciplinary control of the police authorities are performing what are purely state function. Even assuming the applications of the Home Guards Act to the members of the force, which is revelated is that under the Home Guards Act, Home Guards on duty are public servant, and while called for duty have the same power, privilege, and protection as available to the member of the police force. This court, in the case of the, there is an observation
by referring to various judgment. My lord, we kindly come to page number 28, that is paragraph number 9.
No, you see, Mr. Vishnu, you have to show us that whenever you were in the home guard,
Yes, sir.
there's there was a seniority list.
Yes, sir.
And then you were superseded. That's why you are challenging, you are saying that you are challenging the 38/2023
Yes, sir.
gradation list.
Yes.
Correct?
Yes.
In order to demonstrate that you were superseded,
Yes.
in order to stay the operation. Otherwise, we can always say that since you have made the challenge, any promotions granted
Yes.
or any absorption granted by the seniority list shall be subject to outcome of the writ petition. So otherwise, what happens is everything is stalled. But unless you can show, if we can show that, yes, this is the seniority list which have been tinkered with.
Yes.
To downgrade you and to upgrade someone.
Yes.
Then we accept your statement, but where is that comparative examination can be done? How it can be done?
Our affidavit in the paragraph 7 and 9.
The reason is very simple.
Yes, sir.
Let us say A is in number 1.
Yes.
He will get a promotion or sorry, absorption.
Yes.
Now we stay that. Therefore, he doesn't get it. We don't know when we hear the writ petition next. Therefore, in the process, he may retire and therefore he doesn't get the benefits. He will get a notional benefit.
Yes.
Correct?
Yes, sir.
So that is one aspect. But in the second aspect is that if you are entitled to and somebody is promoted, he can be again recalled by the order of the court. But if he is found entitled to, he gets the benefit of promotion. He continues with that. This is the difference between the two.
Yes, sir.
To stay the operation of a
Gradation list.
gradation list and to make it subject to outcome of the writ petition, two different ways of looking at it.
Correct.
Please tell us if you can show the comparative examination, then it's okay.
Yes.
Otherwise, we'll not stop promotion.
My lord, unfortunately, in this petition, my lord, what happened is like when I was absorbed, after the absorption, only this final gradation list was done. I was absorbed in the year 2020. Now, my lord, this is of 2021 also it was absorption list was made. But at that point of time, my name was not reflected there. But on the next writ petition, my lord, item number 45, that comparison I can show, my lord, because in the year 2021, when I was given the retrospective seniority, the final gradation list of 2021, same list, my lord, which I'm challenging in the next item even. And even in the draft gradation list, my lord, in the next item, that particular period was considered. But in the final gradation list, it was completely erased. But on the other hand, serial number 9, Anukal Sinha, serial number 7.
Yes.
This particular person was given retrospective seniority. That is considered.
He is also from the same force.
Same force, my lord. We were also under the same category. My lord, if lordship allow item number 45, my lord, I can show the comparison of it.
Yes, yes. Do it. Item number 2 is 45.
45, my lord.
Yes.
45, 10%. 45. My lord, page number 59, my lord.
Yes.
59, this is the final gradation list, my lord, which was in the year 2021.
Yes.
Now, coming to point, my lord, the candidates list, final gradation, 11, 12, my lord. Ranjan Kumar Barua, serial number Ranjan Kumar Barua, Mukta Bahadur Chetri, my lord, with retrospective seniority of Subedar with effect from May 2015, my lord.
Correct.
Here, this is the reflection which is shown here. My lord, make the next page 63, my lord. This is the draft gradation list of 3rd February 2023.
Yes.
Page number 64, my lord. This is the draft provisional gradation list. Serial number 3, 4.
and 5, my lord. That is with retrospective seniority of Subedar with effect from May 2015. This is granted. But if I come to my lord may also take note of Anupal Sinha, serial number 9,
Yes.
with retrospective seniority. Now, this is the final gradation list, my lord, which I am challenging. Lordship may kindly come to page number 68.
69.
68, ma'am.
68, yes.
Yes. 68, this is the final gradation list, my lord. In the final gradation list, on page number 69, my lord, serial number 5 and serial number 6, my lord, my retrospective seniority that has been erased. But Anukul Sinha, that which I have shown earlier, lordship,
This is
with
maintained.
retrospective
Okay.
seniority of Subedar, that still remains in his case.
This is made out a case. Okay.
Will not be reviewing the very fast there to demand. So we need to file affidavit, madam.
You file it, but he's without a case for stay. If his seniority has been erased, then this, what do you call this rule, 15D comes into play. He's entitled to a stay. Next one. The learned counsel for the petitioner has asked for his prayer for interim relief. First off, in support of his prayer for interim relief, the learned counsel for the petitioner has referred to the provisions of clause D of Rule 15 of the Assam Home Guards Service Rules, 2020. And it is submitted that in case of any changes in the order of seniority of any person in the rank of Subedar, or in case of superstition of any person in the rank by omission of his name, the committee is required to record in writing the reasons for such change or superstition. Full stop. By referring to the final list of final gradation list of Subedar, which is annexed as Annexure 5 to WPC 619 of 2024. It is submitted that that against the persons whose name appear in serial number 10, 11, and 12 of the final gradation list, which was notified on 18/5/2021, their seniority with retrospective effect in the cadre of Subedar was given with effect from May 2015. By referring to the final gradation list of Subedars notified on 3/2/2023, which is annexed as WPC 619 of 2024. It is submitted that as against the name of persons at serial number 2, 3, 4, and 9, the seniority is granted with retrospective effect in effect from May 2015 and May 2018. Full stop. By referring to the impugned final gradation list, the 28/8/2023, it is submitted that the entry of retrospective seniority of persons at serial number 5 and 6 has been erased, and therefore their seniority is not considered with effect from May 2018. So accordingly, stop. Next part, accordingly, committee submitted that as per the current practice in that is being followed in the Assam Police, in terms of seniority in the provisional gradation list of Subedars of Home Guard organization, persons are absorbed in the Assam Police. Accordingly, it is submitted that if the seniority position of the petitioners is erased, they would lose an opportunity of being absorbed in the Assam Police in the current vacancies. Next paragraph. Notwithstanding that the learned senior government, additional senior government advocate has opposed the prayer for interim relief, but considering the projection made by the learned counsel for the petitioners, court is inclined to hold that the learned counsel for the petitioner has been able to show that his seniority position in the final gradation list has been altered. Therefore,
the petitioner, he was not a regular platoon commandant. Petitioner was not no, regular, on my paragraph 11, we have stated our affidavit, were not regular platoon commanders in pursuance of the order of those 17/6/2015 passing WPC number 3688/2010. The petitioner were put under cadre course training. He was sent to training, thereafter he come training, then he was regularized.
No, you see, I've given the reasons. If you can show us that if he is not a platoon commander, he will not be entitled to absorption. That is not the
case.
Not your case. So therefore, if his name is in the seniority, you see, everybody does not get an opportunity of becoming a platoon commander. Platoon is how much? 12 in Assam Police?
12.
12. How much is platoon in Assam Police?
14, I think 14.
It will be 12 then. It will be 12. So, okay, whatever 12 or 14.
14 or 14.
It's okay, whatever 12 or 14. So everybody doesn't get an opportunity of being a platoon commander. Within Subedar rank, will not be able to getting it. So, and deny that promotion to him.
So we, as the private respondent, they have appeared. The matter may fix for a hearing, then all lordship will pass the order.
Let him pass. Let him
Because as we have filed already affidavit about clearing our stand, my lord.
Let him file an affidavit.
Yes. So no interim order may be, my lord, passed on that.
The respondent authorities are directed not to give effect to the final gradation, impugned final gradation list of Subedar dated 28/8/2023 till the next date of listing. Next, the petitioner shall produce a certified copy of the order before the respondent number. Before whom we will produce?
One, two, and three. It's only 3 also.
Director General of Civil Defense and Commandant. General of Home Guard.
Respondent number 2 and 3 to bring the order to notice of the state authorities. On the next item,
Yes, my lord, there is an affidavit we have filed. There is an affidavit that we have filed in item number 45, my lord. With regard to paper publication, lordship, that was not filed.
That was directed to be handed over to me, my lord, in 13 May, but he has not till had not handed over the paper publication. Order dated 13/5/44 item number.
Item 45.
No, no, তুমি তো দিয়ে নাই মোক। 13/5.
13?
30, no, item number 44, my lord.
No, that is done.
Oh, no, 44 is over.
Over.
44, we have taken notice and there, you want to file an affidavit?
Yes.
Right, somewhere in that item, earlier item. The learned counsel for the newly imputed private respondent shall praise for and granted time to file affidavit in opposition in the matter. How much time? Then it goes after vacation. Press for granted 3 weeks time to file affidavit in opposition. Next for a list on 22/7/2024.
27.
22/7. And in this next item, 45.
Yes, lordship. There is an affidavit we have filed, my lord.
Okay.
As per the direction of the honorable court of 9/4/24.
Okay. But you should give a copy to him, Mr.
It is already served, my lord. He have already taken step and accordingly the report has been submitted. But for item, this is the first time after I have filed the affidavit, it has come.
Okay, but just give a copy to him.
Yes, please. My lord, I have submitted the copy to the connect council. I have already. Fine.
But this is a K. Vishwakarma as counsel for the petitioner. And Mr. T.C. petitioners and Mr. T.C. additional senior government advocate appearing for the respondents. Next one. Next, learned counsel with the petitioner has submitted that pursuant to order dated 9/4/2024, the petitioner has taken steps for service of notice on respondent numbers 4, 5, and 6 in a substituted manner by publishing the same in 2 local newspapers. Stop. By referring to affidavit filed on 9/5/2024, it is submitted that the notice was published in the newspaper, in 2 newspapers, being I don't know why you save ink, I don't know. It gives so much of trouble. You say one English and one vernacular. Now name you don't give. Why you are saving some ink?
My lord, page number 18 and 6, paragraph number 6, my lord. Notice published as a publication in Assam Tribune newspaper, English newspaper, my lord. And in Dainik Assam newspaper, my lord. There is
in Assam Tribune and Dainik Assam published on 20/4/2024. Most of the original newspapers are also enclosed there too. Accordingly, notice on the respondent numbers 4, 5, and 6 is deemed to be duly served. So none appears for the said respondents. Okay. List on same date. Okay. Take back your gazette.
Yes. I oblige, my lord.
Oblige.
46.
Yes. Meet is an option. Mother, this case is all about the functioning, the way the human mind works, Miller. It's about a promotional examination to the post of the rank of sub-inspector of police. In a nutshell, Miller, if I may just indicate.
Every time a new problem arises, I get a new problem in my head.
May I just point out, Miller? It's, as I said, it's all about how beautiful a human mind is, how it functions. So for the promotion exercise to be carried out, all were eligible, no difficulties. They had to take the test, no difficulties. Everyone took the test, but the circular said that the board had a power to fix, I use the words, minimum qualifying percentage of marks, unreserved, general, whatever, SC, ST, whatever. So they had the power to fix minimum qualifying percentage of marks. As a normal man, I would think 30, 35, 40, 45. My lordships, that's how we go normally. Qualifying percentage can be this way. I think that way. Some people thought it the other. They thought 36.8 should be the cutoff mark. And I got 35.6. The thinking of that mind would be in the record, that file, that what goaded them to put that percentage as the cutoff percentage. And I say it's absolutely arbitrary. 26 vacant posts are.
It won't be.
I would address your lordships on that. I'll come to that. They come up with a step.
Because you see, I'm a person who is involved in many such recruitments.
My lord,
we don't record reasons why we give cutoff marks at so and so.
Fair enough. If that be so, then the bar, the bench or the bar, whatever you call it, it stops at 36.8. My lordships, I cleared. I got 35.6 and they stopped at 36.8, and not that posts are not there. There are posts. 26 posts are there. And they indicate in everything vacant due to non-availability of reserve category candidate. I am a reserve category candidate from STP. I am before your lordship saying that if your reason is that it's vacant due to non-availability, my lordships, the page 32 for a moment, page 32.
We can't enter into that arrangement.
They cannot supplement with reasons that I'm on, I'm on that aspect of the matter. They're supplementing with reasons. Page 19, page 32. 32. This entire group is the list of candidates, who sailed from. Now, at serial number 19, lordship sees, first page, serial number 19 is an STP with total marks 92. I turned the page and the next STP lordship is at 24. Lordship is there. Is vacant due to non-availability of reserve category candidate. I scored 89. The halting at 92 or my scoring of 89 being not up to the mark, or that they're saying that vacant due to non-availability of reserve category candidate, things do not gel out, Miller. There had to be a reason. Now they filed an affidavit. In this affidavit, if my lord would have the affidavit, page 43, third paragraph, if I may read, of the affidavit. May I read it? As per score sheet received from SEBA, a total of 117 number of candidates could score 40% marks, that is 100 marks out of a total of 250. all these 117 were selected as general category candidates. Now, vacancies were calculated as per existing rules of Government of Assam, as per which for a total number of 11 unreserved seats, the corresponding quota of candidates of STP would be 15, STH 8, SC would be 10. My lordships, pausing for a moment, vacancies are figured out prior hand. Vacancies were never on the anvil of how many unreserved categories candidates could pass. That's the first thing which I would like to address your lordships. Whenever there's a selection exercise, be it direct recruitment or promotion, we know the vacancies, the anticipated vacancies, it may flutter here and there. But to say that 170 is unreserved cleared and calculating or computing from 117, we got these numbers that would not be in the correct canons of service jurisprudence. Number one. Number two, the second page, Lordship has the chart. The cutoff for the first page, it says cutoff marks on the extreme right, The first page, the table, the extreme right is the cutoff marks. So general cutoff marks is 100. Scheduled caste, it's 90. Scheduled tribes hills is 83. And scheduled tribes plain is 92. My lordships. The entire idea of reservation is to ensure participation and no more. On the lines drawn on caste system. On the caste, scheduled caste, scheduled tribe, OBC with horizontal and vertical intersections and all. Here is a case where scheduled castes vis-a-vis scheduled tribes plains, the scheduled tribes plain has a higher cut of 92 and the scheduled caste has a lower cut of 90. That again does not gel with the reasons. I could understand had they come that 92 would be the scheduled caste and 90 the scheduled tribes. I could still understand a rational thinking because they could not have fixed the percentage after evaluation of the marks. The reason is they had said in page 42, the last paragraph, they took a decision at the level. The departmental examination board, which was authorized to fix the minimum qualifying.
You corrected records. The correct numbering will be page 48 onwards.
That's what I had. Anyway, internal page 3 perhaps.
It's okay.
Internal page 3. It's there affidavit.
Internal page 3.
Internal page 3, the last paragraph. The last part of that. The departmental examination board, which was authorized to fix the minimum qualifying percentage of marks, as per circular mentioned above, discussed the modalities and fixed the minimum qualifying marks at 40% with the approval of the DGP Assam for general category candidates via minutes of its meeting dated 25/1/2024. My lordships, the same meeting required them to fix the marks for all. It cannot be in a scenario with any examination, whether it's conducted by the High Court, the judiciary, the executive, anywhere. If it's a selection, the vacancies must be known, number one, and the qualifying percentage you may not disclose. I do not say that they had reason to disclose, but no, in the meeting reached 25/1/2024, they ought to have reached that, yes, 40%, 36.8% would be, we'll fix it. They could have. Then, lordship, I would be on one page. But perhaps, yes, this reason was taken prior and before knowing 92. The scope of discrimination would not be there, although I would advance it. But here, may I pray that the records of 25/1/2024 be produced in the court? If they had not fixed the percentage, and then they had thought that 92 would be for STP and 90 for the SC, apparently bad, and the next man, I have a fair chance to be considered for promotion on the merit of my performance in the test. That's my case. The arbitrariness is writ large. I rest my case.
Yes, Mr. Agrawal, what do you have to say?
My lord, I am appearing for respondent 6 my lord. My lord, we have conducted the departmental examination only. Promotion is up to the department. We have
Mr. Agrawal, introduce the record of this meeting of 25/1/2024 in a seal cover.
Lordship, the intention of the department is only to select the best candidates, Lordship. And Lordship, the examination is also already over, Lordship. The unsuccessful candidates can appear again, Lordship.
This will produce that the minutes of 25/1.
Lordship.
All sides are represented. The prayer made by Mrs. Manika and counsel for the petitioner. The learned government advocate shall produce the minutes of the meeting dated 25/1/2024. Which is referred to in paragraph 7 of the affidavit in opposition filed by respondent number 5. The copy of this admittance shall be produced in a cover for the perusal of the court.
Would the Lord be pleased to fix a date for that?
Will it go to 17th of July?
Very grateful, obliged.
Deeply obliged, Lordship.
To the problem is, I'm sorry, I'll not be able to take up any other matters.
Lordship,
Any interim order is passed, you can request the, you can give the number to the court master, will extend the interim order. Yes,
Lordship, item 52, Lordship, contempt matter, pension matter, Lordship. Can it be on 14 or 21st?
pension matter.
42,000, yes, Lordship.
Okay, let's take note of the pension matter.
14 or 21st?
He'll take the call.
But there was an interim order operating, that needs to be
One
extended.
second. That last matter, interim order passed to this and extended to the Minister of Justice.
Obliged.
Okay, I first will take note of that.
51, there is urgency list, item 51. 13 or 14, there is a suspension matter. 51.
51. Okay, 51 also. Okay.
14.
He'll give the dates.
Item 59 was for correction, my lord. Correction in the custodial, my lord, in respect of respondent number 1, my lord.
50,
59, my lord.
59. Costed of,
Respondent number 1, my lord.
okay. Who is appearing for the others, forest and finance? IA for correction of cost title. We allow that. Respondent one, you made a mistake. Okay. Heard-
Yes.
Heard Mr. D. Kalita, counsel for the applicant. Also heard. Eighth Article and government advocate appearing for the state. Forest will be there. Mr. D. Gogoi, standing counsel for the forest department. Finance, is there. Mr. Arbor Pujari, standing counsel for the finance department. And AG was Mr. Barba, Mr. C. Barba, and standing counsel for the AG. Next, this interlocutory application has been filed for correction of the cost title in respect of respondent one. Stop. Prepare for correction of the cost title. Stands allowed. Stop. The petitioner, the applicant, the Learned Counsel for the applicant shall submit a amended cost title to the amended cost of the writ petition to the AUJ. Civil pending section. Upon receipt of it, shall make it a part of record of WPC 2572 of 2024, and also make necessary correction in the central registry after the matter will be listed in court.
In item 60 also, your lordship, I am seeking for correction of the cost title. Item 60.
60. Cost title in respect of?
In respect of the title of the petitioner, your lordship.
Okay.
The title of the petitioner has been written as Begum, your lordship. It will be Khatun, your lordship.
60 of the same correction of cost title of the name name of the petitioner in the connected writ petition. Allowed sense, isn't it? Here the respondents would be for government was Talukdar for AG, your name?
Tinglung on behalf of RK Talukdar.
You write her name, huh? Dazi, take her name. Appearing on behalf of Mr. RK Talukdar. Standing counsel for the Accountant General. And Mr. B. Govil, and standing counsel for the Health Department. For government, you will be there. Oh, sorry, not just the sick case, correspondent three. Correction of cost title in respect of name of the petitioner. About same order, correction of cost title to AOG. Okay.
Please, lordship, item number 48, some urgency is there, lordship. Date may be fixed, so
What is the urgency?
lordship, the petitioner was selected for the post of lordship, land record assistant, lordship. In spite of that, he was not allowed to join in the service, lordship.
48.
8, lordship.
Okay, 48 also.
Lordship, 47 also.
What is the urgency?
Lordship, is a compulsory time, lordship.
Lordship, in this case, we have received the pairwise comment 3 weeks time may be granted, Lordship, or fine.
Okay, how much time?
Lordship,
How much time?
3 weeks time may be granted, Lordship.
It goes after vacation then. Okay, both sides are represented. This are they with an CEC case for is granted. Time to file affidavit in opposition to the matter. Same shall be filed at least 2 days prior to the next day processing. Next list on 22/7/2024.
Bless.
57, madam. Content matter, madam. The order has been complied with.
Item
57.
57. 57. Okay. Mr. S.K. Roy, counsel for the learned counsel for the petitioner, submits that that as per his instructions, the order of the court has been complied with, and therefore he has instructions not to press the matter. Mr. D. Nath, learned counsel for the respondent, is present. The matter says post on satisfaction. Sorry to keep you waiting, Mr. Goswami and all everyone.
Next state, Lordship, 61, intended to continue with this.
Okay.